Ready for you.
Okay, good.
And what? 10:08?
You got,
I can't get through to her. So I have a bill down in Senate Education and they're like over an hour behind.
okay, the time being 10 past 10, we'll get started here with our public hearings. Before I start, I just want to embarrass my daughter, Joelle. Joelle, stand up. She's here to see how things work at the State House.
Or don't work.
Okay, now we'll start with Senator.
Apologize at the beginning here.
Okay, Senator Lang will introduce the bill.
Thank you very much, Mr. Chair. Thank you, members of the committee. I'm glad to be back in House Ways and Means. My first committee when I served in the House of Representatives was here in the House on Ways and Means. So 432, an old topic up for with the new bill. Advanced deposit wagering. This is basically betting on horses. The ability to, go bet on the Kentucky Derby online. This bill has a different wrinkle to it. It's unclear at the Attorney General's office whether this was legal or not legal, and the bill was originally brought forward to request a lottery in the Attorney General's office last year, and we ran into some headaches, and so we rejiggered it and made it look different and brought it back. This bill establishes that process would be legal, require that people get licensed to be able to provide those services. Those licensed entities would pay a tax on the handle. That tax would go to the lottery. In the new wrinkle in this bill, in keeping with the theme that I've heard from this committee over and over again, charitable gaming is about charitable gaming. It's about charities. So what this bill seeks to do is, without trying to create a huge amount of workload for the lottery division, where the bill would take the revenue, which is estimated a little over $200 million a year, $200,000 a year, $200 million. We were talking about a different thing, but $200,000 a year. Allow lottery to pick a third-party intermediary, not-for-profit, to be able to manage that money and issue grants to charities within the state who don't currently participate in charitable gaming for whatever reason, whether they're on wait lists or whether they just never applied for it before, but who allowed. So in the vision is that we would have somebody like the Center for Nonprofits that knows charities across the entire state to administer this program, receive grant requests, and then issue the grants out and complete a report back to the lottery to show how all the money was spent, what charities got the money, what the purpose of the money was. That's the bill in a nutshell. Happy to take questions.
Thank you. Do we have questions? Yes, Representative Doucette.
Thank you, Mr. Chairman. Thank you for taking my question. You referenced it was Senate Bill 190.
I don't remember the number from last year.
That
But
came out of this committee, ITL. I think it was 15-4, voice voted on the floor, and you said you jiggered this one. The jiggering I see is you've changed it from the money's going to, instead of the education trust fund, it's to some extra party for distribution for charities. What else has changed in it? Anything?
the tax rate is
that?
different as well.
Okay.
The tax rate is in alignment with, so again, under I'm going to use the word retail, although I don't know if that's the right word. Charlie will correct me if I'm wrong. But the OTB we currently have now, off-track betting that we currently have now, you can go to the Brook and place a bet on a horse race, has a tax rate. This put the tax rate for this and the tax rate for that in alignment. So in the old bill, that was not true. The tax rates were different. So this puts the bill in alignment with current tax rate that are charged for the OTP, or the off-track betting on horses that we do now at the Brook.
Follow up?
So the current tax rate is dictated by RSA 284, and there's only one entity in the state that's licensed, and maybe I can ask Lottery about this. one entity, which is the Brook, that can take simulcast wagering legally in New Hampshire right now.
That is my understanding, although I think they're two eligible. Only one actually has one.
Okay, I've heard I've heard many an argument about this being a gray area with the Interstate Racing Act or whatever. My contention is, and my understanding of the law, at least New Hampshire state law, is you have to hold a license. And I think the federal statute, I did some notes and some research, and let me state this. The Interstate Horse Racing Act deems a wager on horse racing across state lines is legal provided the wager and the method of the wager is legal in the same state where the bettor is in the state where the race actually takes place. So in the federal statute, it talks about it being legal in the state that it's taken. In order to be legal in the state of New Hampshire, you have to have a license under RSA 284. So this, in my humble opinion, is something that needs to be addressed.
That's the intent of the bill, is to address it, is to make it legal and make a license requirement, make sure it's clear that you have to get a license to provide the service in the state of New Hampshire and pay a tax.
Thank you, Mr. Chairman. And as I've contended in many of these hearings, the state is owed revenue, rather large revenue in my estimation, and it needs to be pursued. So I'm totally against this bill until such a time the state pursues what the states do, with all respect.
Mr. Chair, if I can, again,
Sure, yeah.
understand the whole point of the bill is to be absolutely clear, to give businesses that want to do the work, do this function, an ability to do the function. I understand that there may be past practice that is not clear, has not been enforced, but that doesn't mean that we shouldn't look forward and whether or not we want to allow our citizens to do this function and whether we want businesses to offer this function in the state of New Hampshire. This bill is a forward-looking bill, not a backwards-looking bill. I'm looking going forward what we want to do and make absolutely clear. So there is no question, because apparently there is in somebody's mind, and it may not be mine, may not be yours, but there is in somebody's, to make it absolutely crystal clear that this function's allowed, that the activity is allowed, that we encourage businesses to come into the state to provide this, pay the tax, and we're going to use that tax to benefit the charities in the state of New Hampshire.
Follow up. Okay, so by that logic, and let's speak logic, somebody's been taking these bets for decades, continues to take these bets. Others are not taking these bets right now, and is pushing very hard to pay a tax, to pay 1.5% out of the revenue they're already gathering. For what purpose? Does that make sense to want to take a percentage out of your profit line because it's a gray area? It doesn't make sense. Something's not right here. And what I believe is not right is the fact that this should be litigated, this should be looked into, and this should be pursued because it's been an illegal activity for decades under RSA 284, and the state is owed its end. And moreover, brick and mortar places like the old Rockingham Park, I'm from Salem, lost revenue. The Brook right now loses revenue. The only operator who is legally licensed to take this kind of betting. And if I was, taking these types of online bets, I'd probably not be too concerned with pursuing legislation that's going to take money out of my pocket unless there was an issue with it. So I think it needs to be looked at further, and we need to go forward with it after it gets looked at.
So again, this is not a retrospective law. We're not allowed to make retrospective laws by our Constitution. We can't make a law that looks back and forces activity based on prior actions. We can only make laws based on today going forward. And that's what this bill seeks to do, today going forward, whether or not this committee thinks that advanced deposit wagering or betting on the Kentucky Derby should be legal in New Hampshire. And if we, on your phone or through an advanced deposit wagering process, should that be legal? That's the question. past practice you can take up at the Attorney General's office and see if they want to pursue an investigation, they want to pursue the DRA or lottery, whether they want to pursue prior taxes. That doesn't mitigate or do away with the reason for this bill, which is to make it going forward legal and to allow revenue again to go to our charities to support our citizens here in New Hampshire.
Representative Southworth.
Thank you for taking my question. Could you say a little bit more about how the money is going to get to charities? Because that's different.
Sure. So I'll give you the perception, the envisionment is. It's in the bill. So again, the lottery would find a third party administrator, take an RFP, do an RFP for it. I'm thinking someone like the Center for Nonprofits could put in for the RFP and manage the grant. It's basically that's what we're doing is we're creating a charitable fund grant at the state level and allow that administrative agency, the administrative third party administrator to issue the grants. And then when they issue those grants, so again, the Northfield Little League says we need new uniforms. We're going to put a grant in for $7,500. They would review the grant, see whether or not it fits the criteria. So again, one of the criteria for a charity to be eligible for grants is that they don't currently participate in charitable gaming, right? We're not looking for people to double dip. We're looking for reaching out into other areas of our state, other charities within our state, and give them an opportunity for the grants that they need. So the Little League doesn't participate in charitable gaming, and they in the state of New Hampshire, and they would issue the grant, and then they would report on an annual basis, the Center for Nonprofits, here's what we did with all your money, the $200,000 you gave us for a grant, here's how we gave those grants out.
Follow up?
Follow up?
I think the grant approach is interesting. It is a change from some things that have happened in the past. My follow up is right now a commission is studying all this. And one of the issues is how charities get money and how it is fair and so on and so forth. I'm just wondering, should we pass this before the commission has done a report on what they recommend?
So while I do serve on that commission, and we are looking at the way charitable gaming operators select their charities, we're not looking at about and maybe I don't want to misspeak because we're not at the conclusion. So it's again, I'm doing it based on what my perception of of it is that we're not necessarily looking at how we get money to charities who aren't participating in charitable gaming. It's only for operators and how operators manage the charities within the gaming operation, gaming facility. So this would still reach out beyond that model.
Okay. Thank you for clarifying that.
Sure.
Representative Platt.
Thank you, Mr. Chair. Thank you for taking my question. If we were to pass this bill, Representative Doucette was talking about past history. Would this color that past history and make a case for the person, the entity who was violating all those years? Say, well, it's legal now, and it's 1.5%, so we backcast to 1.5% instead of some other number.
So I guess, and I don't mean to argue, but I would make a statement that it would be just the opposite, that by passing the bill, it gives the Attorney General a clear line to say that prior to this, it was an illegal activity and you are due the money. But again, I don't know how you get money from someone who's done illegal activity, but other than to bring a criminal charge against them, they would have to do something like that. So again, I think that this is not a retrospective law. Lottery could easily talk about, your experience of any licensee within the state of New Hampshire and whether or not they've been violating this law or not as a item under license requirements.
Representative Fellows.
Thank you, Mr. Chair. Good morning. I have a question about the part that says hire an administrator to determine how to distribute that money that comes in. And the estimate that we have is about 200,000 a year that would come in. And you described what that administrator would do as receiving requests for grant funding and reviewing that. To me, it seemed I would expect that administrative person to cost at least $50,000, which would be a year, which would be a quarter of the money that's coming in. And wouldn't it make more sense to just let that money go into the education trust fund and then you'd have no loss for that, any sort of administration to go with that.
Sure. Thank you for the question. So again, I'm trying to find it. Give me 1 second. There's a cap on the revenue that the third party administrator is allowed to take. And if I remember right, it's 10%. I'm just trying to find it. Thank you. Page 4. So there's a cap. So again, the idea being that the person who's doing this is already doing grants, and that this would just give them a little more work and have that person that's already issuing grants. So the Center for Nonprofits does do things like check grant distribution from other revenue sources. And so again, I would say that this would just give them a little more revenue to help alleviate the new administrative overhead. But it's capped at 10%. So $21,000 based on the fiscal note would be their maximum they're allowed to request. They could request less based on how they administer and how efficient they are. And to answer your last question, so the question always keeps coming up in this committee is, can we divert gaming money to things other than education, right? And so the answer is yes, and I think you're going to get a letter. I spoke about this prior if you haven't gotten it already, from the Attorney General's office, that says that if you remember in 1990, we merged lottery and we used to have our own gaming commission, and the money was unrestricted. We could do what we want. The legislature could do what we want. Lottery money, which is scratch tickets and Megabucks and Mega Millions and all of those games of lottery, that lottery is restricted. So it's clear that we can divert this money again, and keeping in mind, just like we do with charitable gaming, right? The whole point of the charitable gaming is the charities, right? People would say in this committee. And so I'm trying to keep with that intent of what games of chance and charitable gaming were for. It's for charities, and to keep the money in that realm.
Representative Spilsbury.
Thank you, Mr. Chair. Senator Lang, I'm going to ask you a question of interpretation. So
Sure.
on page 3, this provides line 30 and 31 that charitable grants from eligible contributions to charitable organizations can go to those who are not participating in charitable gaming. And then on page 4, the last in the list of what the charitable third-party financial intermediary will be doing says in J, line 14 and 15, limit and condition charitable grants so that they are dispersed equitably throughout the state. Now, there's a vast universe of charities that are, under the first of those two provisions I cited, not currently involved in charitable gaming. How
So-
do you envision that this authority in little j would be interpreted?
Thank you. So-
dispersed equitably throughout the state. What does that
Thank you
mean?
for that. So the intention was to make sure that if we happen to hire an administrative organization that was from Concord, that the only people that ever got charitable grants was from Concord. We wanted to make sure that it was geographically dispersed throughout the state. So that line is to give them direction, to say that you need to look beyond just your own town that you're in. We look at, so again, we talk about wait lists that are on there. So a charity could choose not to do the wait list and just apply for a grant and get off the wait list. The charity could, because they're not participating in charitable gaming, they don't get dates because they're on the wait list. So they could choose to do that. Again, the goal was to make sure that a charity from Pittsburgh, New Hampshire has just as much chance of getting a grant from this organization as a charity from Nashua.
So I just would point out that's interesting. I appreciate your interpretation. And I see when it says dispersed throughout the state, you have a geographic point here. That eluded me completely until you just explained it.
Representative Elberger.
Thank you, Mr. Chair. Thank you, Senator, for taking my question. I'm a little bit confused here. I often find myself this way. When you look at the fiscal note, it's the last 2 pages. It points out that the Lottery Fund, Education Trust Fund, lottery revenues credited, blah, blah, and it talks about the revenue projections. From this, it looks like the revenue would be going to the Education Trust Fund. Instead, it's being directed, the revenue here looks to me like it's going to be a net gain for the Education Trust Fund. Because the note talks about the Education Trust Fund.
Either I don't have the same note as you.
It's a chart. It's a chart.
Oh, you have the as introduced version, so there's a new version?
Ah, sorry.
That's, if you look at the amended version, the fiscal note is different.
All right, well then, let me follow up, Mr. Chair.
Follow up?
Thank you.
Thank you. Why are we not giving the funds to the Education Trust Fund instead of to charities?
Sure. Thank you for the question. So again, the idea being is keeping in line with gaming in New Hampshire's purpose has been, we've made a legislative decision to have gaming money revenues go to charities. With in games of chance and this kind of horse racing, unlike lottery, which we've made a distinct constitutional provision to say it must go to education. So don't get me wrong, the legislature could choose to send it to the Education Trust Fund. My point is that this is, in theory, new revenue, in keeping with the new revenue, in line with our past practices of having charitable gaming be focused on charities. It's been a significant topic in this committee room, as well as mine on the other side of the wall. That making sure the money stays within charities for that. Lottery money stay in education.
Yeah. Anybody else? Yes, Representative Ames.
First question is in response to a question from Representative Southworth. You said that you thought that the commission that's looking at the new gaming laws that relate to charitable gaming would not be addressing the subject that's in this bill. And as you know, I too sit on that, and you did qualify what you said, saying this isn't something that the commission has yet reached. But I would say that I would think, as one other member of this commission, that it's very likely that there would be interest in this. In effect, it's filling out the picture of charitable gaming, looking at charitable entities that are not, for whatever reason, maybe they just couldn't get a slot, but participating in charitable gaming and providing something for them. So maybe you could respond a little further about why you think this would be outside the purview or interest of the commission.
Well, it's not part of the 5 charges that commission has. And while we've expanded that and fairly significantly in that commission, what we're looking at, again, we were looking at charitable gaming in terms of games of chance, HHR, those things. This is a new activity that doesn't currently exist as far as the advanced deposit wagering piece. So again, I don't know. I'm trying to remember if we even talked about it in the commission. But I think that this bill fulfills the mission of keeping gaming and revenues from gaming in the charitable market. And they may be interested in it and may like the fact that, in fact, we are reaching out beyond the charities that can only get slots, that we're looking for other opportunities to be able to use charitable gaming monies to support our charities here in New Hampshire.
Follow up?
It's really a further question.
Okay.
And it's really about the order of magnitude of the money that's going to be potentially funneled into this new intermediary that would then send the money out to charities. And the picture I have in my mind is that we're talking about, to start with, the only numbers we have here are perhaps 200,000 or a little less than that when you get through the 10%. And then you got, I have no idea how many charities are out there, but there are a lot of charities. And you've got this one criteria of dispersal, geographic, that was mentioned in another question. But how in the world are you going to pick between all these charities other than give a dollar to each one of them or something like that? I mean, you're giving a lot of authority without any direction from the legislature to a private intermediary who's going to somehow either go through a lottery system or do something maybe more selective that's totally selective and give all the money to something that sounds good. But how do you respond to that?
Thank you for the question. So again, you got to start somewhere, right? So my goal is, again, this is roughly after expenses, a $200,000 grant that the state's issuing. We regularly go through processes for issuing grants. We don't equally disperse the money when we issue grants in the state of New Hampshire, whether it's from the water fund or whether it's from anything else, right? People base their decisions on the merits of what the grant request is. And what I'd say is that to use my example, the Little League in Northfield that asked for $7,500 is told they're only going to get $5,000. I promise you, they're still going to be happy, right? They're still going to very much appreciate the fact that they got some assistance from the state to help that charitable organization.
Okay. Thank you, Senator.
Sorry, I don't mean to be rude, but I need to run back to Senate Education.
No problem at all. Okay, next up I have Peter Bragdon.
Thank you, Mr. Chairman, members of the committee. For the record, Peter Bragdon, a senior policy advisor at Preddy Strategies, here today representing Churchill Downs, best known obviously as the home of the Kentucky Derby, something that was mentioned earlier by Senator Lang. The longest continuously run sporting event in America. A week from Saturday will be the 150th running of the Kentucky Derby. Churchill Downs is a publicly traded corporation with gaming facilities and tracks in over a dozen states and over 30 facilities. And we do have an app for advanced deposit wagering called Twin Spires that is used nationwide. In New Hampshire, I guess I would direct your attention to the last page of the bill as amended by the Senate and the fiscal note. And really just the first two lines of the fiscal note. This bill seeks to license and regulate advanced deposit wagering on horse racing. And then in parentheses, advanced deposit wagering currently takes place in New Hampshire and is not subject to regulation. The Interstate Horse Racing Act of 1978 authorized electronic betting on horse races. States could choose to license and tax those activities. They could choose to ban those activities effectively, or they could do nothing at all. And a number of states, a dozen or so at least, including New Hampshire, did nothing at all. And so a number of companies, including Churchill Downs, had operated advanced deposit wagering in the states that did not do it because it was authorized by federal law. And I think that's the key sticking point with those who think there was something illegal going on, is that a number of companies, ours included, operating under the assumption that it's allowed by federal law unless the state does something more restrictive. So that's kind of where we're at. Back in 2021, late 2021, early 2022, Churchill Downs expressed interest in purchasing the Chasers Poker Room in Salem. And in its discussions with the Lottery Commission and the Attorney General, they expressed their concern about this so-called gray area. And obviously, as we all know, I think the Lottery Commission is pretty strict with respect to its licensing of operators for charitable gaming in New Hampshire. And it was clear to Churchill that being involved with advanced deposit wagering in New Hampshire would be in a gray area, may not look good in terms of being a operator of charitable gaming in New Hampshire. So we voluntarily stopped doing the advanced deposit wagering and pledged to work with the Lottery Commission to put together some kind of, to support a bill that would establish once and for all, clearly in state law, whether it's legal or not. I guess I would say to you, you should make a decision. is it illegal or is it legal, and pass a law to clarify that. I will say that if you pass a bill like this that authorizes it, it's effective. I think the effective date on this is July 1st of this year. It only applies, this illegality only applies to anything that happens after July 1st. If for some reason the Attorney General determines that something illegal was happening, which we very much doubt, nothing prevents the Attorney General from going back prior to July 1st, 2024, and taking action on that. So I think the crux of the matter is because New Hampshire hadn't taken any steps regarding advanced deposit wagering, we were operating under the federal law, and I think that's how we end up where we are now. Right now, we basically have an unlevel playing field. We have companies that have been operating. So back in 2022, almost 2 years ago, Churchill voluntarily stopped advanced deposit wagering in New Hampshire. Other companies have continued to do it for 2 years. I would suggest that if the Attorney General thought that this was an illegal activity, that they would have issued a cease and desist order to those that have continued to do it. So basically what's happening is our competitors get to do it, but we don't. And all we're asking is make it clear in law. And everybody's got a level playing field. Consumer protections are involved, and it would be better for everybody. And then finally, I know there's been some questions about the additions in the Senate regarding the charitable third-party financial intermediary and whether it should go to this charitable group to do something or whether it should go to the Education Trust Fund. If this committee decides that they want to just go back to the Education Trust Fund, we'd be happy to work. It's a relatively simple change to the bill to make that happen. So happy to work with the committee on that if that's your pleasure. So I think that's the main points I want to make is we do not feel this is an illegal activity. We do feel that the federal law governed this because New Hampshire took no action. Now, some states took action and they effectively made it difficult or impossible to do advanced deposit wagering. And so we don't operate in those states. In those states that do license it, then we operate in those states as per their licensing. And all the other states like New Hampshire, we operate where the bets basically are being accepted at a site in Oregon, which all the operators use. And that's kind of a consolidated area for all the activity. So with that said, I'd be happy to answer any questions.
Thank you. Representative Doucette.
Thank you, Mr. Chair, and thank you for taking my question. I'm curious as to if you can give me a date when Twin Spires started taking bets in New Hampshire.
Thank you for the question, Representative. I don't know that, although based on the discussions at the hearing for Senate Bill 190 last year, you had suggested that was 2002, and I don't know any better than that. I assume you were informed on that, so I'll go with that if that's what you think it is. I don't know.
Follow up.
And you stopped taking bets in 2021?
Probably 2022.
22, okay. And what I'm hearing you testify to is you believe this is legal, but you stopped taking the bets because it's a gray area?
The regulator of charitable gaming in New Hampshire felt it was a gray area, and if your regulator feels it's a gray area, then probably pay attention to what they say.
Okay, thank you.
Representative Schoenberg.
Thank you, Mr. Chairman. Thank you for taking my question. Representative Doucette brought this up earlier, I believe. If this bill, as presented, becomes law in New Hampshire, how many other states would it be acceptable in that would accept these wagers?
I don't know the exact breakdown of states that specifically authorize it, states that say nothing, and states that prohibit it. There's a handful of states that I know prohibit it. My recollection is there were a dozen or so states, maybe somewhere between 12 and 20 probably, that the law is silent on it. This law would only apply to New Hampshire.
Representative Almy.
Thank you. That leads into my question on, I was hearing that the federal law says that you can only do this within the state that the racing is carried out in. But we've got other programs doing this still in New Hampshire, and how many of them are there? Can you tell us who they are? They aren't here, are they? They're in Las Vegas and places like that.
So I don't know exactly. I know there's 3 primary companies involved in advanced deposit wagering. One is Churchill Downs, not in New Hampshire currently.
Yeah.
Another is Express Bets, who I believe has a lobbyist present here. I believe they're from Rhode Island. And a third one is called TVG, I believe, and I'm not sure where they're located. At least one of those other ones is also a publicly traded company.
So they're still doing it in New Hampshire, though the federal law apparently just doesn't allow them to do it in New Hampshire.
Well, no, I would say that they are accepting bets from New Hampshire residents, and they believe that under the federal law, they're allowed to do that. And they are not seeking to be licensed in New Hampshire to operate charitable gaming, so they, probably have less concern as to what the lottery and attorney general may think about the gray area.
Representative Ulrich.
Thank you, Mr. Chair. and Thank you for taking my question. I'm trying to understand the logic of your argument that this is a gray area or it's not illegal. And it seems to me that the argument is the federal government can tell the states what to do, even if it's illegal in the state. That seems to be the argument. New Hampshire doesn't have a law regarding this, but it does have a. Anybody know how to take these new things and put them on mute? Anybody? Because they don't.
Do not disturb.
Oh yeah, thank you. So besides, it's just someone trying to sell me Medicare insurance. The argument would be that an interstate law, interstate commerce, which requires action in the state for it to be legal under interstate commerce, but when there is no law in the state, it's not illegal because there is no law, but it's illegal in the state because there is no law. You see where I'm?
Not really, no.
Yeah, well, neither do I. So I really don't understand the argument there.
Don't understand my argument
Yeah,
that it's legal.
yeah.
Yeah, I mean, our view is the Interstate Horse Racing Act allowed for electronic betting on horse races and allowed states to regulate and or tax it. And those states that chose not to, I see what you're saying now, those states that chose not to, then it's something that's allowed by federal law.
Representative Ames.
Just a couple of questions. The first is on the charitable part of this thing, the new part. And you said you really don't have a position on that one way or the other.
Correct.
And I understand that. I'm wondering if you must have participated in the Senate side of the public side of this bill, and my question is whether you observed that there were comments or information provided about this part of the bill. Was that testified to, and can you share that with us?
My recollection, and it's just that, so there's a disclaimer there. My recollection that this amendment regarding the charity issue was an amendment brought forth at the executive session, and I don't believe it was part of the original bill, and I assume we testified on the original bill, but maybe not. But I'm pretty sure the amendment that made the big change came in at executive session.
It's in accord with my impression. And then, if I may, the other
Follow-up.
question is on the order of magnitude of revenues. And we have in this as amended version a number of 212,500 as I guess the amount that's would be transferred either to intermediaries, or we went back to the other route, it would go to the Education Trust Fund. And it might be a slightly different number if we did a different rate, but whatever. My question is whether you think that's in the right range, the 212,000.
Thank you for the question. My understanding is it probably is. I know starting in 2019, 2020, the Lottery Commission was surveying the various providers of advanced deposit wagering. I think initially in 2021 or so, they tried to do some rulemaking and realized they didn't have the authority to do the rulemaking. But in advance of that, was collecting information from the providers of advanced deposit wagering. And so Lottery, I'm pretty sure, has access to what the total wager is for New Hampshire residents. I've been told also compare it to some similar states to see if it was in the range. So I think it's based on a total wagering of $17 million, and this would be 1.25% of whatever that was. So yes, I think it's pretty close, probably.
Thank you.
Okay, thank you. Representative Doucette.
Okay, thank you, Mr. Chairman. Thank you for taking my question. You stated the state didn't do anything relative to advanced deposit wagering. It's just brought to my attention, and it's actually written in this bill on page 3, line 25 through 25 and 26, talks about Parapool Rule 525, which specifically was enacted by the Racing Commission here in New Hampshire to allow for advanced deposit wagering. And in order to do so, you needed to comply with 284. It seems yet again, we have state statute, state law that dictates how ADW happens in New Hampshire, and the gray area is getting darker, is my comment on this.
Thank you for the question. I'm unaware of exactly what that refers to, and I can certainly look at that.
I can provide you with it.
And I would say again that regardless, passing this bill takes effect July 1st. It does not in any way erase whatever happened prior to that. And if the Attorney General determines that there is some illegality there, they have the ability to pursue that. This does not erase that.
Okay, thank you for your testimony.
Thank you.
Next, I have Sean Thomas.
Thank you, Mr. Chair, and members of the committee. Thank you for this opportunity to testify today on Senate Bill 432. I work with Demers and Praisall here in Concord, and here today representing ExpressBet, an ADW provider. And so what I want to do today, I think you are all pretty familiar with the concept. Again, this is sort of the second go around. You saw this, a very similar bill last year. I, again, like Mr. Bragdon, want to highlight that first sentence of the fiscal note because I think very simply, this is what this bill is all about. And it says this bill seeks to license and regulate advanced deposit wagering on horse racing. Advanced deposit wagering currently takes place in New Hampshire, is not subject to regulation. So that's really what this is all about. It already takes place. We operate currently in the state. You heard from Churchill Downs, obviously, they ceased operating. We continue to operate. We disagree, obviously, that this is illegal activity. What I will say is, and I want to clarify about ADW, we're talking specifically about live horse racing, and that's it, nothing else. This doesn't go beyond that. It falls into its own separate category. So last year you had a bill that would have addressed online gambling generally. Think, poker. That's different. This is different than sports betting. It's not charitable gaming. It's not HHR. So this really is its own entirely separate category, and it's the only form of gambling that currently takes place in New Hampshire that isn't regulated, and that's really the purpose behind this bill. It licenses and regulates the industry, and with regulation, obviously, comes the revenue, whether to the state or in this case to the charities. So very simply, at the end of the day, what this bill is all about, you have gambling that currently takes place in New Hampshire that will likely continue regardless of how you decide to vote on this bill. The question then with respect to Senate Bill 432 is regulation and revenue or status quo, which is neither. So that's really the question before you today. And then I want to address some of the sort of the legal aspects, or at least some of the arguments that we've heard today. So, in Representative Euler, you had asked about the federal law. So what I'll say about the federal law is that, so the federal law permits this activity, but it doesn't preempt the states. So the states then can restrict it further, and many states have chosen to do so. They can either regulate and license the activity, which many states do. They can prohibit the activity, or that third sort of category of states, which is where New Hampshire currently falls, is they just remain silent and don't address it at all, and that's sort of the gray area that you've heard about today. But those sort of how the states address this issue falling into one of those three buckets, that's really well established. And I'm not aware of any examples where courts have decided that states that are silent with respect to this issue, or that this activity is illegal in states that have chosen to remain silent with respect to this issue. Also in New Hampshire, specifically, the legality here was investigated by the AG's office back in 2022. The result of that investigation was this legislation. So you have this legislation was really based on the AG's office's recommendation. It was drafted and is supported by Lottery. I think that's all very important. I will also say, when we were discussing this bill last year, I had conversations with Lottery and asked them, is this something we can just deal with in rules? And the answer to that question was no, because they believe without this bill, they have no authority to regulate ADW. So again, the fact that they have no current authority to regulate ADW, I think speaks to the legality of ADW in the state. And then I think the argument, the idea that ExpressBet or the other providers may owe taxes going back a number of years, and yes, we've operated for a number of years, anticipating, I'm sure, Representative Doucette's question. I don't know exactly when ExpressBet started operating, but I can tell you we formed in 2002, and if it wasn't 2002, it was probably shortly thereafter. So, yes, it's been many of years. But this, so the only tax rate that currently exists in the state is the tax rate with respect to simulcast. So that's what is going on currently at the Brook. They do simulcast. That's an off-track betting facility. That's the one location that currently offers simulcast. And I want to go back then to the line that Representative Doucette already called out on page 3, lines 25 and 26. So this exception, which was added this year, is an exception specifically for the simulcast providers in this state. So the Brook, the other facility that could, if they wanted to, offer simulcast but don't currently, is Belmont. This exempts them from these licensing provisions. It says, you're already licensed for simulcast purposes. We're going to spare you this additional process. But the fact that that exists and it calls that out and exempts them is all the more reason why simulcast and ADW are two separate things. And then, so with that all being said, really, I don't think there's no legal basis. Again, this was already investigated by the AG's office. And then on top of that, I would add, and this is hypothetically, right? Again, we don't think there's really any legal basis or what we're doing is illegal. Hypothetically, if there were a case, if the AG's office decided we did want to bring a case, I want to turn your attention back to the fiscal note. This is $212 is the estimate per year, and that's across multiple providers. So let's say there was a case and the AG's office sought even 10 years back. We're talking about $2 million. Again, that's across multiple providers. That's an expensive case to try, and they likely wouldn't recoup the cost of that case. So another reason why it's unlikely that a case will be pursued in New Hampshire. And on top of that, I guess what I'll say is if this bill were to pass, that doesn't preclude the AG's office from still filing a lawsuit. So if the concern is revenue, lost revenue, then you would want to pass this bill immediately, because then the revenue starts coming in immediately. And I think the fact that the legislature now has seen this bill last year and this year, if it weren't to pass again, I think that makes a potential case even more difficult, because the legislature has seen it twice, they knew about it, and chose to do nothing. So I think that potentially hurts the case as well. So I guess in summary, I mean, if you think the industry should be regulated, if you think the state is missing out on revenue, then this bill makes all the sense in the world, and we request your support. The alternative, obviously, is the status quo, which is no regulation and no revenue. Happy to take any questions.
Representative Doucette.
Thank you, Mr. Chairman. Thank you for taking my question. Mr. Thomas, you just testified that you spoke to Lottery and they told you they have no authority to regulate ADW. Can you tell me who told you that at Lottery?
I had a conversation with, I believe it was John Conforti.
Thank you.
And so, again, to your point, I think the concern here is that there's an issue with legality. There's nothing that we're aware of. We're not aware of any issue, because we've never heard from anybody, whether at Lottery or the AG's office, that we should cease operating. Obviously, Churchill ceased operating. I think you heard from them today. That really, it sounds like, was a business decision based on their charitable gaming facility here in New Hampshire. We obviously don't have a charitable gaming facility, and we're not aware of any issue with legality outside of the conversations within this committee. This is a bill that wasn't opposed in the Senate, and I don't think you'll hear any testimony in opposition today either.
Follow up.
So ExpressBet is taking, who you represent, is taking bets at present.
Correct.
And if this legislation was to pass, ExpressBet would be paying 1.5% on the bets taken.
1.25%.
I'm sorry, 1.25% on the bets taken. Why is it ExpressBet is here pushing this legislation to take revenue out of their own pockets?
Yeah.
Because if it's legal, it's legal. You're taking bets now.
Right.
Why are you sitting in front of us?
Yeah, I mean, that's a good question. So I would say two things. One, there's obviously a consumer protection aspect here, which I think, there are bad actors in the space. So with respect to consumer protection, this is a good thing. Two, it just makes sense for us. We are already licensed. We operate in 38 states. That includes probably, I think there's about 28 where we have an actual license and are regulated. There's about 10 which are similar to New Hampshire that are silent on the law. We still operate it, and obviously we're licensed and regulated in other states and follow those rules. And just, I would say, take pride in sort of being a safe and secure platform, the fact and being licensed and regulated wherever possible. And so this was a bill, again, you heard about the investigation back in 2022. This bill was the result of that investigation. And we think it makes more sense to sort of work with the state and work with Lottery than fight this issue, because we are licensed and regulated in other states.
Representative Almy.
Thank you. I'm trying to figure out the relationship, what the rulemaking section does. You say that do they have any ExpressBets and TVG or whatever the name of that is? Do they have a physical presence in New Hampshire?
No, I'm not aware of any physical presence.
So they're just taking bets across the internet.
Correct.
Yeah. And, but it looks like you said that Churchill Downs did buy that poker room in Salem. So they have a physical presence. Under rulemaking, it includes, it is amending in the rulemaking section, not here, but it says the sale of parimutuel pools is authorized under 284, 22, 22A, 22B, and 22D, which is the new advanced deposit. But 22B is the charitable gaming horse historic horse racing, which is a slot machine,
Right.
or as near to it as you get. There, the owners are calling them slot machines now. And does that relate to what is going on in this bill? Namely, will all of your three be taking bets? I guess it would be particularly be Churchill Downs, be taking bets on historic horse racing machines and producing and having accounts that people could put money into and then play those machines until they run out of money. Is that part of this
No,
deal?
absolutely not. So ADW.
Why isn't it?
Well, ADW for one is separate and walled off from all other types of gambling. So that particular provision grants rulemaking authority to lottery. It just adds now ADW. It has no impact with respect to what already exists for HHR. And as you know, HHR is limited to a certain number of facilities, currently physical locations, and ExpressBet doesn't have a physical location. You know that Churchill Downs has a physical location, but what they do at that physical location is entirely separate from ADW. So ADW operates sort of in its own lane.
Where in the law does that happen?
Where does what happen? I'm sorry.
Sorry, follow up. On that, ADW is totally separate from everything except, well, you're using it for live horse racing only, but.
Right. And I mean, that's laid out here in this particular bill. It's with ADW is specifically with reference to parimutuel wagering on live horse racing according to the Interstate Horse Racing Act. And that's it. That's all this covers. That's the very first line, top of the bill.
It's what? But where, okay, what do you, the interstate horsing in compliance with this section and the Interstate Horse Racing Act of 78, which I don't know. Because when they put historic horse racing into the law, they put it in the racing section. And I have a great deal of difficulty differentiating what applies across the two of them. They are very different things.
I guess, again, what I would say to that is currently ADW is not addressed in state law. This would add a section specific to ADW. All other forms of gambling that currently take place in the state already exist in law. There are sections specific, obviously, to charitable gaming, to HHR, and all those things. This is entirely separate and would exist separately in its own section.
Okay. Yes, Representative Fellows.
Thank you. I have two questions.
Yeah.
One of them is a short answer. The age for participation in this bill is 18, and I'm just wondering if you might know the other states that you deal with, if the age is 18 or if it's something else. And my other question is, the entity that owns your business, ExpressBets, do they have subdivisions that are involved with any other kinds of wagering or gambling?
Yes. So, first question, age. That I don't know the answer to. I assume it's 18. I think the way this bill was drafted was using sort of other state sources as a foundation or a template. So I assume in other states it's most likely the age is 18. That may be a product of federal law as well. I don't know for sure. And then your next question. Remind me again. I'm sorry.
So
Lost my
it
train of
has to
thought.
do with the business structure that
Oh, yes,
the
I'm sorry.
company you're in.
Yeah, so ExpressBet is a subsidiary of a larger company. That larger company has other companies involved in other gambling activity.
Okay. Thank you very much for your testimony. Oh, did I miss one? Ah, Representative Sandberg.
Your dad's not colorblind, is he? Mr. Chairman, thank you. I don't think your daughter heard that.
It's all right. I'm not colorblind, just in case.
Oh, okay. Because we do have red lights in this state, sir. Okay. Regarding Representatives Doucette about business models, does Express Bets believe in the New Hampshire charitable gaming approach as part of their business model?
Meaning money going to charities?
Money going to benefit other organizations and people in the state.
I mean, I think that's a great thing. We obviously support the bill as it exists today with money going to the charities. I will tell you, in other states passing similar licensing and regulation, there has been a similar move. I'm familiar with at least one state. I remember exactly where it is. But also in that case, when they license and regulated ADW, they send that money to charity as well. So it's not a novel concept, obviously not in this state either. So we do support it, but to the extent, and there's been many questions obviously about the charitable piece of this, to the extent that's sort of a sticking point or it causes confusion, we're most concerned obviously with the underlying regulation piece.
Okay. Thank you very much for your testimony.
Thank you.
And I've got one more pink card. It is Michael Haley from the Department of Justice.
Good morning, Mr. Chair and honorable committee members. My name is Michael Haley. I serve as the Director of Charitable Trusts at the Department of Justice. I'm here just to speak about the charitable aspect of this bill. I don't have any knowledge about the lottery aspect of this bill. Our office, the Charitable Trust Unit, is charged with protecting the public's interest in organizations and assets dedicated to charitable purposes in New Hampshire. And there are currently approximately 5,600 New Hampshire-based charities. I realized that was a question earlier on. We don't take any position on the bill. I'm just here to provide some information, particularly about some of the wording relating to the charitable component of this bill that could be read as inconsistent with other laws. And if the committee was planning on moving forward with the bill, might want to look into those. I have pretty much 4 points to mention. They're all on page 4 of the bill. So I'll go through those, and I'm happy to take any questions about any of those. The first point is on page 4, lines 3 and 5. This section of the bill refers to the charitable intermediary organization and requires that it not have an owner or operator who also owns or operates a charitable organization participating in charitable grant program. The concern here is that charities don't have owners. By definition, the assets of a charity belong to the public because the public is the ultimate beneficiary. So I suspect that the intent here was to prevent a director or officer of a charity, someone who perhaps sits on the board, an executive director, a chief financial officer, someone like that associated with a charity from holding one of these positions. If that's the case, I would suggest that words such as director, officer, or trustee would be more in line with how charitable assets are held. The second point that I would like to raise is on line 12 of page 4, and it refers to there being no carry forward of unused eligible contributions in the first program year. I'd just be curious what the plan would be for any assets that were not used. I'd want to bring to the committee's attention a U.S. Supreme Court case that originated in New Hampshire, the Trustees of Dartmouth College versus Woodward. It's an 1819 case, so quite old, but still good law, that places some restrictions on what the government can do with funds that have gone to a charity. And so in this case, I don't know what the plan would be if there was money left over, if that was going to be taken back by the state. You would want to be careful about that particular Supreme Court case.
I'll just interrupt you for a second, Representative
Yeah,
Almond.
that wasn't line 12.
I was
Are
just
you
going to say, I
talking
think we must be looking at different versions.
Line
Oh, maybe I apologize. Do I have an old version of the bill? I have a line that says there shall be no carry forward of unused eligible contributions. Am I in the wrong?
That's line 8.
Okay. I'll stop referring to lines because I imagine I have the wrong version then. Is there a line in the current bill that talks about maintaining separate accounts for charitable funds and operating funds? That's 11. Okay. So on line 11 then, the all funds of a 501c3 are charitable funds by definition. So I'm not entirely sure what the intent of this line was. Perhaps if the intention was to delineate the grant funds versus the operating expenses, that grant funds would be a more accurate description here of what's happening. And then I'm assuming the next line below that, not award a charitable grant to any lineal descendant or equivalent step person of any officer, director, or employee of any charitable third-party financial intermediary. Here, you would want to be careful about any language suggesting that a charitable grant could go to an individual. I believe that the intent here is that the charitable, the intermediary would be making grants to other charities, and a charity must be designed to benefit the public and not to benefit private individuals. So again, if the intent here was to prevent the charitable grants from going to any organization that had as a director, officer, or trustee a lineal descendant, then the committee might want to consider language that made that clear. And as a general comment from reading this over with limited background and limited time, I didn't see a definition of advanced deposit wagering in it, which would have aided me in trying to review what this bill was trying to do. That's not pertaining to the charitable section, and it may be elsewhere in law. I only got this yesterday afternoon, so I apologize if that is defined somewhere.
Could you give or email a version of your proposed
Certainly.
changes? Thank you. Is that what you want?
Yes, this is the clerk speaking. You went 78 RPM. I can only type at 33 RPM. So if you could provide that material, that would
Certainly.
be great.
Okay. Yes, Representative Elmy.
Would it be worth asking him if he could redraft those sections for us to take a look at? Instead of just commenting on what we need to change, but change it to what?
I could certainly, I would have to get approval from our office about providing specific bill language, but I could certainly look into that.
Okay. Thank you. Representative Spilsbury.
Thank you. I thought those comments seemed to be well taken, except I'm a little confused on the first of your four comments. So on line 1 and page 4, the words "not have an owner or operator," ... that doesn't relate to the charity that's receiving the grant, right? It relates to a charitable third-party financial intermediary, the one who's going to make the allocation decisions. So I'm not sure what your objection is.
Thank you for the question. The concern is that charitable intermediary also can't have an owner. There's no such thing as the owner of a charity, and the intermediary is required to be a 501c3 organization.
Are you suggesting that the charitable intermediary must itself be a charity?
I believe that's what the bill says, at least the one that I have. It's in the definition, it says that an intermediary has to be recognized under 501c3 of the Internal Revenue Code.
Thank you for drawing me to that.
Yes, Representative Ellery.
Oh, thank you. That brings up the perennial question, since New Hampshire recognizes a lot of things that are charities that aren't charities that are charities. So under the scheme that you're describing, the dispersing agency would have to be a 501c3. Now 501c3s are then restricted to giving to 501c3s.
So thank you for the question. 501c3s are restricted to carrying out their charitable purposes. There are charitable organizations that make distributions to entities that are not recognized as 501c3s. For example, there are trusts, the purpose of which is to make distributions to a particular church. And the churches typically are not recognized under 501c3 as tax exempt, even though they are tax exempt entities. They do not have 501c3 status. So it could. I'm not an expert on federal tax law. I could see there potentially being concerns about distributions made to the 501c4s, the 6s, the 10s, the 19s that New Hampshire, in some circumstances, also calls charities. That would have to be something that the third-party intermediary would want to be careful about, I suppose, when seeking their 501c3 tax exemption and reporting their distributions to the IRS.
Follow up, Mr. Chair.
Follow up?
Well, there's a lot more than that involved. Although you did hit on the points regarding that, particularly in New Hampshire, where our definition of charity is not very clear. But let's just take I think a C4, which is an educational. I think C4 is educational. Is it?
Social welfare organization.
That's social. Well, there's several social welfare. 6, 8, 10. But let's take a school. So you have a school, and it's not profit because it's an educational facility, but it's we'll go with Bangor Catholics because it's stereotypical. Maybe they're running gaming to support Presentation of Mary down in Hudson. Could the distribution agency then distribute money to them?
To a school?
Yeah.
To
Which is not a 501c3.
The language in this bill does not preclude that. I imagine that the organization that has this recognition as a third-party intermediary would need to be careful about how it did its federal taxes to determine if those distributions were consistent or inconsistent with the 501c3 purpose.
Okay, another follow-up, Mr.
Follow-up?
Chair. Finally, who's going to oversee the distribution agency, and how much is that going to cost?
Thank you for the question. So if this is a 501c3 that is based in New Hampshire or does business here, it would be required to register with and report to the Director of Charitable Trusts. We would not typically get that deep into the operations of a charity to determine if every distribution that was made was consistent with federal tax law. That's usually the IRS's role. What they would report to us is their IRS filings, their board information, their governance procedures, things like that. I suspect that there's some role for the Lottery Commission here, as they're the ones who are choosing this third-party intermediary and whether they would relicense them in any following year. And there's a reporting to the Lottery Commission listed in this bill, from my understanding. But they would be required to register and report to our office.
Representative Malloy.
Thank you, Mr. Chair. Thank you, Mr. Haley, for taking my question. This may or may not be relevant to this conversation, but you mentioned that I think I caught this, if a charity, a 501c3, goes out of business, you said that the beneficiary of that, what's left of the assets, I think, goes to the general public. Is that because in many, if I may, my experience is that in many cases there is a plan laid out by many of the 501c3s to go to a succeeding organization or another organization. Could you help me with this?
Sure. I apologize if my comment was not clear. What I was trying to say was that a charity does not have any owners. So a typical corporation, the members of the board of directors have some ownership interest in the organization, and oftentimes when the organization dissolves, the board of directors gets to keep whatever's left around. They have some kind of ownership stake in it, or the shareholders or whoever. With a charity, the ultimate beneficiaries of a charity have to be the public and not any individuals. So it's not possible to have an organization formed for charitable purposes where if it dissolves, the board members or the members get to retain those assets. Typically, as you said, when a charity is formed, it's required to have a dissolution provision. That's part of their articles of agreement that are filed with the Secretary of State. And those must say that upon dissolution, the assets go either to another 501c3 or a government entity. They are free to prescribe more specific specifically if they have a particular charity in mind or a particular government entity, but at best it must go to another C3 or our government entity.
Thank you. You got to my question. Thank you. Yeah.
Thank you. Let's get Representative Fellows. We're way over. Let's try to wrap up quickly.
So I have a question about this structure that's in the bill says that the state will give the money, transfer the money to a 501c3, which is a charity. And when they fill out their 1099, is that the right number? Are they going to show the money that the state gives them as making doing charitable work, and then will the second 501c3 that the town that gets the money for the football field or whatever, they're also going to show those same dollars as charitable work, which is kind of double counting?
Thank you for the question. I believe the form you're thinking of is the 990, the IRS form 990. The IRS form 990 notes the general revenue. It does not provide a particularly detailed breakdown of where money comes from specifically. So sometimes I believe there's a line that says government grants, and I suspect that's where this would be categorized. Within the IRS Form 990, there is a Schedule B that is filed with the IRS, but not filed with our office because it's confidential information that we're not entitled to. The Schedule B provides more detailed information about specific donors, specific organizations that give grants, and we don't have access to that information.
So follow up. So I'm
Last follow up.
I'm asking about when the identified charitable third party financial intermediary sends the money to the more local entity that is this end that's going to spend the money. When they do that, are they reporting that as a charity?
Yes, they would also be reporting that as charitable income, but that's not a very unusual setup. There are a lot of organizations that are set up to receive grants and then make sub-grants, and sometimes those sub-grantees make further sub-grants. That's not an unusual setup for a charity.
Can I just have one more follow-up?
No, I'm going to end it now.
Okay.
Thank you, Mr. Haley.
Thank you very much. I will send you an email with those comments.
Thank you. Yes, Representative Almy.
Could I just ask one quick question to the director of the lottery?
Sure, Director of
No, the director of the
Lottery.
Sorry. And I get two.
Good morning, Mr. Chairman, members of the committee. Charlie McIntyre, Director of the Lottery. With me is our Director of Sports Betting, Danny Maloney.
Thank you. Representative Almy.
Thank you. Could you just provide for me where in the racing statutes it says that that only live racing would be covered by ADM, ADW, whatever it is?
Well, I mean, certainly historically, ADM has only been live racing. And currently it exists in that form only. The three operators that had been in New Hampshire, which is now two, only take it on live racing, and the players only want it on live racing. You couldn't do it on historic racing because everyone would cheat. Nobody would not bet on Secretariat at the Belmont. You would research your phone and so it would be not a viable product, I don't think. And certainly if it's a concern for the legislature, we can fix that in rulemaking in terms of it has to be a live wager. But it's the only way it's done currently now that I'm aware of in the 28 states where it exists.
Yeah. So in our laws in the historic past, before it came to lottery, it was defined as only live
Correct.
racing.
Correct.
Thank you.
Okay,
sorry-
well,
I'm
since
sorry.
since we have a new speaker here, Representative Schamberg, followed by Representative Ames.
Thank you, Mr. Chairman, and thank you, Director McIntyre. Does lottery support this Senate Bill 432 now that you've heard a lot of this discussion today? Do you have any other opinions on it?
So by and large, the lotteries never supported the expansion of gaming, which this, at the end of the day, looked like it was a little bit. It's really the recapturing of gaming, but certainly we've never historically said we're in favor of gaming. We did ask Senator Lang to look at this in terms of clarifying what had been a practice that existed, because in many ways, we would rather have that regulated market versus an unregulated market. And a number of reasons, not just for the fact that there's revenues to the state, but also consumer protections. In an unregulated market, the consumer is the one who doesn't benefit really, because there's no appeals process with the state with us. And certainly, similarly, when we approached the Attorney General's office regarding fantasy sports, and we thought fantasy sports was not legal, DraftKings and FanDuel went and had a bill passed, and fantasy sports was then legalized in the state, which we now regulate.
Follow up, Mr. Chairman.
Follow up.
Have you had this bill reviewed, or not the bill? Has the AG's office reviewed the legality of ADW here in this state, and that's why we have this outcome of this legislation, would you say?
Correct. It was when we broached the topic with the Attorney General's office, it was suggested then that we clarify it by a bill which would clarify and be based on other bills in other states that also clarified it.
Thank you, Mr. Chairman.
Thank you, Representative Ames.
On the charitable, it's not charitable gaming, the charitable part of this bill that was inserted apparently in executive session in the Senate's deliberations. And my question is whether you think that that is a workable model, and if the numbers that there have been assumed, roughly $200,000, are in the ballpark.
I mean, certainly anything's workable. You know, I often say we don't make policy, we're the instruments of policy. And so if it's the legislatures and the governors wish to do this, then we'll certainly administer it the best we can.
Representative Doucette.
In terms of how much money would,
Do you,
over 200,000? Yes. Yes, I think that's right. I will tell you that historically, when you legalize a activity, it tends to grow the revenue. Not that this is a problem area. I know this is not like sports betting was, where it's a bookmaker and a sports bar. But if you legalize the market, you tend to grow it.
Thank you, Representative Doucette.
I don't mean to belabor this, but thank you for taking my question, Director. But we heard some testimony from someone earlier that stated that the Lottery Commission has no authority to regulate ADW. Is that your position? The lottery has no authority to regulate ADW at present?
I think it's a finer point than that, Representative, and thank you for the question. Current ADW that exists now, we have the authority to regulate. The ability to regulate what is online gaming and horse racing for ADW, I think was in a, I hate to use the words gray area, but was in a gray area. The lottery has the authority to promulgate regulations regarding advanced deposit wagering, and it doesn't clearly define that. That authority pre-exists the internet. And so it's one of those areas where we haven't cleaned it up to account for technology. So if that answers your question.
Quick follow-up. I know we have to move on. So 284, RSA 284 and Parapool 525 doesn't lay it out clearly enough?
It does. It doesn't. So there are certain laws that pre-exist the internet and pre-exist online. And so certainly in the abundance of caution, candidly, I would rather seek the approval of the legislature for doing something than doing it myself, if that makes sense.
Follow up.
I don't mean to belabor this, and thank you for the follow-up. Do you know when the Parapool 525 rule came into place? It was well into the internet age. If my information's right, it was about 98, 99.
Honestly, that was before my time, and that was before they were part of us.
Thank you very much. All right, I'm going to close the public hearing on SB 432. I heard a few sighs of relief there. Okay, we need to get going right away. I will open the public hearing on SB 546. And is there someone here to introduce that bill? Okay, thank you. Okay.
Good morning, Mr. Chair. I think my pink card is making its way towards you. Thank you, Chairman Janigian and honorable members. For the record, my name is Senator Deborah Altschuler. I represent Senate District 24, representing the towns of Exeter, Stratham, Hampton, Northampton, Hampton Falls, and Rye. The Land and Community Heritage Investment Program, otherwise known as LCHIP, has invested $58 million through 564 grants in 198 New Hampshire communities. Thanks to the work of this program that preserves and protects our past so that future Granite Staters will be able to connect to our rich and storied origins as we evolve into our future, 170 historic structures have been rehabilitated and 237,312 acres of land have been conserved. As with any program, evolution is necessary, and the bill before you, Senate Bill 546, is an effort to ensure the grant-funded programs have enforcement fidelity that accurately reflects the processes under which the LCHIP program functions. I am pleased to bring Senate Bill 546 with the wind at its back, having come out of committee in the Senate with unanimous recommendation of ought to pass and a passage on the consent calendar. While I am thrilled to have had the experience of serving on the board of directors for the past year and a half, the details of grant applications, awards, and managements are still relatively new to me, and I am on the upswing of my learning curve. So I am also thrilled to have LCHIP's Executive Director, Paula Belmore, and Board Chair Ben Wilcox here with me to provide the precise answers to questions you may have about the proposed changes to RSA 227M3. And thank you for your time and attention this morning. I will turn over those questions to them if that's okay. Yeah,
That's fine. Yes, thank you. Thank you.
thank you.
So next I'll call up Ben Wilcox.
Great. Good morning, and thanks for allowing me to speak this morning. My name is Ben Wilcox. I'm the chair of LCHIP, and I've been on the board of directors since 2017. So I'm here to express the board's support for SB 546. The LCHIP board includes 4 legislative seats appointed by the Senate President and Speaker of the House. These seats are currently filled by Senators Bradley and Altschuler and Representatives Ebel and Renzullo, all of who sponsored this bill. Since its first round in 2001, LCHIP has been highly effective and as a result enjoys broad public support. And perhaps as a testament to the good work of the Blue Ribbon Committee that led to its creation, the original framework for the program stands for the most part as adopted. However, over the last 23 years, best practices in land conservation and historic preservation have evolved based in part on our experience with the various types of legal arrangements used to accomplish the program's goals. Some we've learned work well and others not so well. That evolution of thinking has led to the need for SB 546, which seeks to remove a requirement that the state be granted an executory interest in each LCHIP-funded easement. To secure the public's investment, the LCHIP statute places 3 specific requirements on LCHIP funded on an easement. First, it must be held by a qualified entity. Second, it must be held in public trust by the state. And third, it must grant an executory interest to the state. LCHIP's program rules add a 4th requirement that LCHIP retain a legal right to enforce any easement and funds, further protecting the public's interest. So that's four areas to focus on. The bill before you today seeks to remove the 3rd of those 4 requirements, the executory interest, but leaves the other 3 protections in place. After consulting with the Attorney General's office at length, we understand that the executory interest requirement isn't necessary to protect the public's investment. That investment is well protected by the other 3 requirements. As stated in the memo from the Department of Justice that has been provided to you, removing the executory interest requirement will not diminish the state's ability to protect its investment and uphold the public trust. So in closing, I'd just like to reiterate that the LCHIP board supports this change, and we urge the committee to vote ought to pass for SB 546, which will reduce the administrative burden placed on LCHIP, the state, the grant recipients, while retaining the state's ability to defend the public's trust investment. Today, I have Paula Bellamore here, the executive director, to help me answer any questions, along with Attorney Alan Brooks from the Department of Justice. So I guess we can open it up to questions. Thank you.
I guess I have 2 questions to start. We talk about the executory interest not being needed. I understand the thought behind that. But there's 2 other areas that have changed here in this bill. The first being on line 5, the word acquire being crossed out and the word provide funding. That seems to me like a major change, because now how are they providing, how is LCHIP providing funding? I guess that's a...
Certainly. Thank you for your question. Since the beginning of the program, LCHIP has not directly acquired interests. Instead, we provide a grant to a sub-agency who then acquires that interest, for example, a land trust or a community, a town. So what I can tell you from my research and reading is that when the LCHIP program was first introduced, SB 401, it actually did propose that LCHIP would first acquire a resource and then convey it to a partner agency, such as a land trust. That was changed during the legislative process to becoming a grant-making program, which we are today and is how we've always operated. I think it was just a Scrivener's error level mistake. We have never acquired directly resources.
Okay. And I guess my second question is on line 27, acquisition of resource assets or related, and now it's, I'm sorry, draw upon funds for the acquisition of, now it's draw upon funds for program purposes. That seems like a much broader
Thank you.
charge.
Yes, it is broader, although I would point you to the original statute or to RSA 227M, which does have other program purposes beyond acquiring resource assets. For example, historic rehabilitation, which is about 50% of our program work and doesn't require the acquisition of assets. So we're simply trying to clarify that the program purposes, which are spelled out in statute, we can draw upon funds for those purposes.
Thank you. Representative Southworth.
Thank you, Mr. Chair. Mainly for the chair, would we say that most of these changes really are in the area of housekeeping, if really you're not going to see much difference from the outside, but we're more clarifying what was in the previous legislation?
That's what I'm trying to determine.
Yeah.
Yeah.
I think...
I don't want to make a definitive statement on that
Yeah.
right now because we're trying to get to that point.
Okay, thank you.
Representative Elmy.
Oh, I thought I turned it on. Sorry. On line 13, you've removed the legal obligations attached in perpetuity, and that's a very important part, but is it just considered to be part of the easement interests?
Thank you for the question. Easement interests should be recorded in the easement deed, but there are other legal obligations that our grantees accept. For example, an obligation to post signs on the property or to acknowledge the LCHIP grant, to monitor the property on an annual basis. Those obligations aren't appropriate in a real estate deed. They are memorialized in a grant contract or a grant agreement that we enter into. So it's along the same lines of the first two changes we've discussed, clarifying what the program is doing.
Yes, Representative Bolton.
Thank you, Mr. Chair. It's just a clarification. So on line 16 of page 1, it says the authority is authorized. What's authority in reference to?
LCHIP is an independent authority of the state. So in the statute, the program is, or the board is often referred to as the authority. And I think Attorney Brooks would probably be more appropriate to explain what an authority is as opposed to the program and the board, because it's
Okay.
above my pay grade.
Thank you.
Representative Fellows.
Thank you. I might understand this a little bit better if I knew what executory whatever is. But in terms of deeds, so am I correct in assuming that LCHIP makes deeds for conservation easements?
So I think your first, the two-part question, your first part is would probably be helpful for a lot of people. An executory interest is a contingent future right in property. So it's a right that can be exercised based on certain future conditions. So in other words, the state could hold the easement or take the easement if certain conditions had been met. Those conditions would be, for example, if the land trust stopped enforcing. And Attorney Brooks can get into the details of why they already have that right under public trust. But essentially, that's what an executory interest is. It's often in the land conservation community, people think that an executory interest is simply a right to enforce. It is not. It is a right to actually hold the property or the resource asset. So it's a very important difference. And the second part of your question was, oh, deeds. So LCHIP does not convey property because we never acquired the property. Instead, we provide funding to an entity who then purchases the property, usually from a private landowner. So we award a grant to the land trust. They use that money to buy an easement on a farm. So the deed is being conveyed from the farmer to the land trust. LCHIP is a party to that because we take a right of enforcement to ensure that we can uphold the investment, the state's investment, but we aren't actually conveying or accepting the deed.
Follow up?
So I'm trying to figure out the way you're doing it or suggesting to do it. If the farmer is holding the deed, what happens if he sells it and, you know, somebody wants to like build houses on it?
Sure.
So will there be something in the deed that says you can't do that? And if you try to do that, the state's going to get it back? Or
Right. So with an easement, it's almost like you have two layers of ownership. So you have owner of the land, the property, and then when we acquire an easement, we're taking a portion of those property rights, which are, for example, the right to build houses on it. And that's what the land trust acquires. So then you have two deeds, remembering that a deed is a legal document, right? So you have two documents. One is the title deed to the property, which the farmer still holds, and the other is the easement in the property, which is held by the land trust, and that runs with the land. So no matter who owns it, that easement stands.
Follow up?
so I thought the easements were in a deed. Are you saying it's a separate document, or is it like a second chapter or something?
An easement deed is a separate document from the title deed or from the fee deed. So if you owned land that had an easement on it, there would be two deeds. There would be the deed to the property itself and the easement deed. I think, and Attorney Brooks could correct me, I think it's possible to have it all rolled into one. I'm not sure about that. But two
I think I've
different
seen it.
pieces of paper.
I think I've seen it all rolled into. Yeah. I mean, I've definitely seen deeds where it's all rolled into one. But it could be, as she says, separate. They could be separate.
Mr. Chairman?
Yes.
Just to clarify, it's typical that someone will already have acquired a property and be the owner, and a deed was recorded to document that transfer. Now, at some point in the future, while owning it, that owner may choose to grant an easement. Could be to the power company, could be to the town, could be for conservation purposes. There's a wide range. So they're most ordinarily separated in time, and the one becomes subject to the other.
Thank you. Representative Malloy.
Thank you, Mr. Chairman, and thank you for taking this question. Is this an example of what we did in Greenland with the Southeast Land Trust and the LCHIP situation? Because this is great, because it's the first time I've really understood the whole thing with your testimony. That's my question. Thank you.
Thank you for the question. Yes, in the case of the farm in Greenland, the Southeast Land Trust, and Brian Hart, their executive director, happens to be here today, received an LCHIP grant, which they will use. I don't think that has closed yet. April 30th. And they'll use those funds to acquire an easement. Just as was explained, the farmer already owns the land, but will sell the easement.
Yep. Follow up. You're right. It is April 30th, and I'm also a trustee of trust funds, and I need to, we need to make sure you get a check by the end of this month. Thank you.
Representative Elberger.
Thank you, Mr. Chair. And this is not a question, it's just a thank you. I represent Nashua, and for those of you who are looking at the back of this, there are two projects in Nashua. I just want to let you know what they are. The Sacred Heart School has been turned into a new home for the Nashua Soup Kitchen and Shelter. In addition to the soup kitchen, there are dormitories for men, single men and single women, as well as apartments for mothers and children. It is a wonderful facility. And the Sullivan Farm has a large apple orchard, and they also have one of the biggest solar panel arrays that I have seen that's not set out in a field. Also wonderful, Sullivan Farm is in my ward, and I invite any of you to come down, take a look anytime you're interested. Thank you.
Thank you. Okay. Thank you very much.
Thank you.
Thank you. The last pink card I have is Brian Hart. Okay. Thank you. We appreciate that. Is there anyone else who would like to testify? That's all I have for pink cards. Seeing none, we'll close the public hearing on SB 546. Okay, now we are
Way behind.
we're about 50 minutes behind right now. Let's see. Now let's get started. We'll get started on some of the work session work to see how we're doing. We need two.
92.
Yeah. Okay, let's see. I'm going to open the work session on SB 472 relative to historical racing, licensing, establishing operations of games of chance for the benefit of the host community and relative to charitable gaming from municipalities and charitable organizations. So let's see, 472. Representative Southworth.
Thank you, Mr. Chair. I'd like to start where we kind of ended last time, which was with all these waiting lists, which we were trying to double check. Were there in fact going to be any slots open to municipalities anyway? or is it just a moot point, really?
That's a good question. Representative Almy, would you like to take
Well,
that?
we forgot to ask the relevant people if we had them here, but I was assured yesterday that this would be, that this does not apply. I'm trying to remember exactly what the question was now. Sorry.
Well, he's asking if the towns or cities would have a chance
Oh, yes,
at this.
yes. That was it. That he was assured that legally, the notwithstanding any provision of law to the contrary, which is what I thought in line 7 of page 2, is on rules over everything that follows it in that subsection in 4A. Namely, that because it's notwithstanding any provision of law to contrary, the game operators are required to annually operate a minimum of 7, but not more than 10 game dates for the benefit of the town or city on rules over, at least that's the way I understood it, sections Roman 2, 3, and 4 that would allow the charity to, all the charities to acquire time. That, now maybe I misunderstood it yesterday, but that would insist that the municipalities be involved in this.
Okay. All right, going to go to Representative Doucette.
And I think I can maybe more directly address Representative Southworth's question. I personally think it's a moot point, and from the information that I'm getting, there are so many charities, I don't believe there'll be that opportunity for municipalities to capture this. I spoke to some of my counterparts here. I've spoken to an attorney that tells me that this language is rock solid, and that the charities will get the preference. We have waiting lists. It's not geographical. So it's my firm belief that we're not going to see this effect on the municipality anytime soon, because that was, as you well aware, that was my major concern. So I'm not necessarily concerned with that any longer.
Thank you. Representative Almy, and then Fellows.
Yes, I do not understand then the notwithstanding any provision of law to the contrary, because we all know that if there are any game dates open still in the game operating schedules, they must be in Berlin, which doesn't produce very much money for the charity that would take it from Lebanon, say. Not that Lebanon is going to, but anyway. So Roman 1 says the game operators have to provide a minimum of 7 days annually to the city or town where they are. And 2, 3, and 4 make that impossible.
Representative Doucette.
My understanding is that first sentence, notwithstanding any provision of law to the contrary, right now in law, it goes to a charity. Goes to a charity first and foremost. And if the charity list is exhausted or another charity can't be, and I contend we have plenty of charities and they will continue to apply, that supersedes anything thereafter.
Yes.
And that's
I
what,
agree with that. I
Yep.
don't agree with, because it says notwithstanding law that already exists.
but the notwithstanding would also, I would presume the notwithstanding would also refer to even this if it passes. Representative Ames?
But doesn't that mean all this language is just a waste of space? That there's host communities are not going to benefit. Isn't that what you're saying?
That's my-
Yeah, that's what you're saying. Because of the numbers of charities that are out there and the waiting lists and all that stuff means that although this sounds nice, host communities aren't going to get anything, right? Do I have it right?
I totally agree, and I think whomever authored this, it may make that person happy to see that as a fallback. I don't believe it's ever going to become that fallback.
So my feeling is that given that that's the case, that within this frame that we're talking about here, this language should not be here. It's just confusing, if anything, and it should be amended out. On the other hand, I also think that there is legitimacy to the notion that host communities incur costs, and there should be some way of providing for that. It's an issue that comes up. It was an issue I remember that was addressed in that big gaming bill that I sort of engineered years and years ago. Host communities incur costs, and it's often a debated issue because some people think casinos sort of engender other kinds of activities, and people argue about that. But still, I think basically there's going to be a call for police response to issues, arguments that develop on site, and so forth, and more cars, and it's natural, it's going to happen, and money's floating around. So I feel that issue needs to be addressed. I suspect it's going to be considered how it's going to be addressed. I don't know. It comes back to that gaming commission that I happen to sit on. You're on it too, and we'll be working through that. So one of the puzzles that I have as we look at bills like this is, do we really need this? As we know that in parallel to this process is something more comprehensive that's digging a little further into the issue. I think the one part of this that's needed relates to the moratorium. If we continue to fail to pass legislation on the restriction of licenses to a finite group of entities, we as a legislature and governor working together, then we're going to roll by June 30th and there'll be no restriction. That's my understanding. I feel we need to do something. We've already sent one bill to the Senate. It's still sitting there as far as I can tell, 112, Senate Bill 112. And in that one, I think you helped to engineer that, Representative Doucette, and that one simply froze the number of entities at the original, whatever, 15 or whatever, plus those in the pipeline as of a certain set of dates. And that does the trick. That contains this. This bill has an end date to that new arrangement, 7 years out, if I remember correctly. And that's, I guess, workable. It seems a little long to me, but, I've learned to be flexible in this business. So that's the one piece of this. I may be missing something else that's essential. And we could amend this bill and send it to the floor, and if it came out, it could be just focused exclusively on this issue of moratorium, the limits issue, and drop the other stuff. I don't know whether we'd be dropping important stuff. I just put that out there, that we maybe need to focus on how we get to what we've got to get to, and push that issue, and maybe deal with these other things too. I don't know. I've talked too much.
Representative Doucette.
If I may, and I know we're in agreement with this, and I think the moratorium is the important component here, and it'll allow for us to have that time we've spoken about many times to review and find out where this is going, where we are right now. And also to this language specific to the municipalities, I may think it's moot. You may think it's unnecessary. Somebody thinks it's important enough to put in there, and for the sake of argument, yes, the municipalities incur a cost. This is an acknowledgement, at least in this piece of legislation, of that, and then we need to work towards in the commission. But I don't think there's a need. I think we should take this piece as written, move it forward, so there's no opportunity for the other body to yet again amend or do something in a committee or conference that might send this sideways, because we do not want to allow for June 30 to come and the Wild West to ensue as far as HHR.
Yeah.
So that would be my personal opinion.
I agree with you, Representative Doucette. In fact, that was my thing. One of the reasons I would like to leave this unchanged is for that. You spoke about things are getting delayed and tied up. If we pass this as it is, it moves on to the governor.
This gets us to our result.
Yes.
Yeah. Did you have a question, Representative?
No, I was just going to say that I agree with everything that I've heard.
Okay. Representative Southworth.
Yes, and I agree too. I phrased it different at the beginning. I do understand if we just send it back as is, that still may get us where we want to go.
Yes. Thank you, Representative Platt.
I was just going to say, I hate to say I agreed with Representative Doucette, but I do.
Many have the same feeling.
All right. I think we will move on from this. We'll close the work session on SB 472. Take this out. Next, I'll open the next work session on SB 432 relative to advanced deposit wagering. Representative Platt.
I want to kill this bill. To me, if this bill got passed, it gives credence to the history where nobody was paying anything and operating illegally. And so I want to address that issue before we pass anything like this.
Okay. Representative Doucette.
Yeah, and I agree, and we've all sat through the testimony here, and what we did with SB 190, which is the exact same language here, and the money was going to the exact place, in my estimation, it should have went, instead of creating another entity to distribute what funds maybe to what charities may be. Fact remains is we have statute in law right now. Everybody that came up here, including the lottery director, said this is a gray area. I suggest it's a gray area because somebody dropped the ball here. And we can't be kicking this can down the road. We can address it going forward, but the fact remains is everyone's on point. We had somebody testifying for one of these people saying, they all said it was legal, but they all said it was a gray area. Okay? And if it was legal, if it wasn't a problem, there's two outlets still taking bets. Why are they here lobbying us to make them pay that 1.25%? You know, the pieces just don't come together for me. So my position is we ITL this and we get some action on this.
Isn't that what, I'm sorry, Mr. Chairman. Isn't that what this is asking us to do? Put some action on it now versus kicking it down the road again. What we are asking to have some rules and regulations We have rules and regulations on everything else, and here we're saying, we're not going to put rules or regulations here. Representative Doucette.
It's my belief and my contention that if one particular, and I've called this out before, if one particular AG doesn't pursue this, doesn't necessarily mean another AG won't pursue this. So if it's legal, take the bets. You've been put on point because under what I've heard in testimony, I think you and I, Representative, should start a website and start taking bets on simulcast racing today because it's legal. It's the Wild Wild West because we don't have statute in place we have written statute that specifically outlines simulcast live racing. We have rules that I quoted earlier that specifically, I found out it was 1997 that Parapool 125 rule came into place specifically for ADW. There is one provider in the state of New Hampshire who can legally take bets, and it goes to the Interstate Racing Act to states that in order to take a bet, the state in which the bet is made, it must be legal. Comply with the laws of that state. The state where the bet originates, it must be legal. Comply with the laws of that state. It's not happening in New Hampshire. It hasn't happened in decades. Somebody dropped the ball here.
Representative Almy, followed by Ulrich.
Yeah, I also do not understand why, I do not believe any attorney general would be following up, trying to accuse these places of a crime so that they can get a penalty out of them, because I don't think the penalty could end up being very much money. And we can't pass law that's punitive, so we can't get it back that way. Punitive backwards. So I think we might as well go ahead and get this thing into a legal position. I just want to make very sure that they never put in accounts, online accounts for slot machines, because too many people who don't have much money could end up spending everything they had saved up.
I wouldn't crack this seal.
Thank you. I'm really confused, and when I was talking with the individuals, I hope that was apparent, because you got an argument that says that it's legal, and we have an argument that says it's illegal. And the argument that Representative Doucette is making says that we already have rules in place. So this legislation isn't necessary because we have rules in place. But the argument that the people putting this forward say we don't have rules. So the question is, do we have rules or don't we have rules? And the AG never answered that. So I don't know where we are. Do we have rules or don't we have rules? Or I shouldn't say rules, laws.
Representative Almy.
We have laws for live racing. We don't have laws for online betting of live racing.
No, that's incorrect. That's
Yeah?
incorrect. Parapool, and I'll send you a copy of it.
Yeah,
That
we
was
ought to get
established
that.
in 97. Lays out what advanced deposit wagering is.
Okay, follow up.
And it does talk
Yes.
about internet.
Well, I don't know if it specifically talks about internet. I can send it to you.
So
Yeah, that would be nice.
we
if
do
could
have
all
rules,
it.
or we do have a
Oh,
law.
We do have.
And the law talks about live racing, and it talks about advanced deposit wagering. Is that correct? Say again?
Representative Doucette.
Representative
That's
Doucette?
correct. I believe that's correct. Let me pull up this rule here. I'm going to send it to the whole committee.
Thank you.
Representative Ulrich, can I ask you a question? Advanced deposit wagering can be done in person. I think that's what the law is indicating at the present point, that you can go to someone and say, hey, I want to put this down. And over the next few weeks, you'll say, I'd like to put this amount of money to them on this race. And someone will send that off. I think this is our electronic age has put us in a little quandary of how we are going to do advanced deposit wagering. I don't think we have an answer on it, and I think someone is trying to say, let's get this clear now. And this would clear up that.
No, I'm going to send it to you folks, but I brought this issue up specifically with lottery years ago and was told it was passed on to the AG. Okay? Years ago, at least 4 to 5 years ago. I sat with the AG last year before this legislation started coming around. Okay? Before it was generated. I was told by lottery it was passed on to the AG when I approached them 4 or 5 years ago. I want to say it's about 5 years ago. When I sat with the AG said, I just heard about it last month. Okay? I have issue here. Somebody dropped the ball. If I wasn't collecting the revenue correctly, let's correct it. But to me, there's too many missing pieces, and I don't think we should cover this up and not address what's owed to the state in revenue. And I still go back to the days I'm from Salem, Rockingham Park. These online outlets incentivized people not to go to Rockingham Park, not to go to Seabrook. Incentivized 5%. Bet with us online. We'll give you an extra $5 on your 100. Okay, plus didn't pay the tax. So there's revenue loss to brick and mortar business here too. And if you can, what you want, this is the truth. This is the truth.
Representative Spilsbury.
Thank you, Mr. Chairman. Separate from and aside from Representative Doucette's reservations, I think this bill is just begging to be integrated into a broader strategy of charitable gaming, and that's why we adopted a bill to create the commission, which is still working on that subject. So I think that the bill has gotten all the more confused by the addition of the provisions in the Senate executive session on charitable gaming. We've got an estimated $200,000 at stake. We have, according to Mr. Haley, 1,600 charitable organizations that are potentially eligible, and we have, some sort of a very vague concept of dispersing equitably throughout the state. I'd like to see this reworked. I'm not sure that these provisions even belong in this bill, but if they do, I'd like to hear that from the commission with a more integrated plan. So I would suggest we not move forward with this bill.
Representative Southworth.
Thank you, Mr. Chair. Just briefly, as we keep going, it seems like there are more questions than answers, which to me says the bill isn't ready.
Representative Fellows.
Yes, I would just like to share with you my concerns about the whole strategy for that charitable third party being able to figure out how to distribute, assuming that they had money to work with, assuming that they had 200,000 and they get 10% of that to do the administrative work to pass out those grants, that is not feasible. You can't do that with $20,000. And I'll tell you why, because these are the steps that they would have to go through. So first step would be they have to advertise the opportunity to apply for the grants. Then they'd have to, of the grants they get back, they'd request applications. They'd have to verify that the organization was eligible. Then they'd have to read the applications, and they'd have to convene a group of people to rank the proposals and select some of them. You can't designate that to a single person to do. And then they'd have to notify the winners. They'd have to distribute the grant money. They'd have to have some kind of audit procedures to make sure that the money was really being spent for the particular activity that the grant asked for the money for. And then for the places that didn't do what they proposed to do for whatever reason, you'd have to figure out how you're going to get that money returned. So you can't do that for $20,000 a year.
Representative Schamberg.
I go back to Representative Doucette again. Did you send that yet, that what you were looking for? Because I haven't received anything, but Tara, I'm in a meeting. All right, but my question goes to this. Does ADW overlap with any other online gambling, or is it a separate unit itself? And if it's separate, and we're letting revenue that we should be getting in the state here, let's go after it. This bill sort of puts us on that path toward it. So if you find that information, let me know, okay? Thanks, Representative Ames.
Well, yours is coming.
Double up is better.
Yes, Representative Elberger.
Thank you, Mr. Chair. I agree with Representative Spilsbury that this needs to be part of a larger encompassing bill about dealing with charitable gaming, and I will therefore agree with Representative Southworth that this bill is not yet ready for prime time, so I'll not be supporting it. Thank you.
Okay. Thank you. I think we've exhausted this one. I'm going to close the work session on SB 432. Okay, we'll now open the work session on SB 59. Yep. Oh, okay. Yeah. I'm going to open the work session on SB 597. Representative Platt.
Yes. First of all, this bill does not apply to Lucky 7 that's still done by paper, but some of them are. This is only with, it's done through a machine, and the testimony was that the people required to pick out, to print out tickets is archaic because people playing the Lucky 7 don't want them, they just leave them there. And no other state requires this, and it's harder to get the machines available.
We've got a discussion going on over here.
Yeah, it's harder to get these machines. They're becoming difficult to get. So this, to me, is a no-brainer to pass.
Okay. Any other thoughts? Representative Southworth.
Thank you. I agree with Representative Platt, and I would say literally, this is a housekeeping bill.
Okay. Representative Fellows.
So, this is my second year on this committee and learning about all the different games of chance that we have. But we passed a bill last year that had to do with the Lucky 7 tickets, and I think it allowed people to have more time, something related to the machines. I'm just getting the impression that these are just turning into slot machines. That's what it sounds like to me, because they're, you know, first it was paper tickets, and then it was you could do paper tickets or on the video screen, and then we did something last year that made it easier. You could play more games or faster on the video machines, and now we're saying, you know, let's just get rid of the paper tickets all together. I don't think it's Lucky 7 anymore. I think it sounds like a slot machine.
Representative Doucette.
Yeah, that's not the case. What these, it's an electronic version of the pull tab ticket. Okay, it's their deal sizes provided by lottery. There's so many winners in a deal of say 1,000 tickets. It has no randomness other than the deal size itself. What this piece of legislation talks about is in those electronic versions of the pull tickets, they generate a paper receipt, a paper ticket, for lack of a better term. And they end up falling on the floor because they're useless. They just generate a piece of paper. So the paper lobby, I'm sure, is happy about that. But the fact remains is there's no need, and we heard testimony to that. This in no way, shape, or form changes the game, changes anything about it. It's still the same as if you were going to buy and pull those 3 tabs and see if you get the 3 bars. Yeah. Oh, yeah. Oh, yeah. And the machines are an electronic version of that. We can talk to lottery if we want, but that's exactly what they are.
Yes,
This
Representative
just
Elmy.
eliminates the receipt, basically.
I believe that in the hearing, we were told by Valerie King that there is a requirement that you cannot, that the button cannot be repressed within 6 seconds. I think it is 3 seconds. And the slot machine, oh, sorry, the historic horse racing machine is how much that you can do it in? You don't know.
Ms. King, do you want to come up here for a second?
Point was, it's not a slot machine.
Yeah.
What I said was correct about the Lucky 7.
Oh, you can ask.
Good morning, Valerie King with New Hampshire Lottery.
Yeah, Representative Doucette.
Could you explain to the committee how the Lucky 7 draw works and the electronic version of the Lucky 7 machines, just so, because there seems to be so many components here in gaming, seems to be some confusion relative to right now that specific device. So if you don't mind.
Right. So Representative Doucette is correct that it is Lucky 7 deal has a set number of tickets with a certain number of winners and losers, which is not the same as a slot machine, which is random, total random of when you win or lose. The amount of time for the tickets, I believe, is 3 seconds. That's set by rule. And historic horse racing, it doesn't speak to that. There is some time in between, but there's nothing set in rule or statute on the time between presses.
Representative Elmy.
Yeah, my concern with electronic machines is simply how addictive is it? And I believe that 3 seconds, of course, this is when they were trying to sell us the historic horse racing machines, that they are estimated at 3 seconds also. So obviously the Lucky 7 machine doesn't, it should be less addictive, but I don't think I've seen one working. I've only been showed the portable version we had to agree to once.
It sounds like the main difference is you either get a receipt or if this passes, you don't get a receipt. Is that paper, not a receipt, paper?
Correct. And I'd like to also point out there is only one manufacturer that I'm aware of that makes the paper, and so they have a monopoly, and that can make it difficult. We had a time when it was difficult to even obtain the paper, and now we made it so it was on demand, and people aren't even asking for the paper.
So effectively, we're operating in a paperless world as it relates to Lucky 7. Okay. Okay. We all set on this one? It looks good. All right. Close the public hearing on SB 597. And I will open the public hearing on SB 585.
Work session, correct?
I said, what did I say? Public hearing? Yeah. Okay, and I don't know what I said previously, but I closed the work session on 597. If I said public hearing, I apologize. So the work session on SB 585 is now open. Representative Platt.
I always stick my neck out by speaking first. Maybe I shouldn't. But to me, this is a good change. It says if there are unpaid rooms and meals taxes, it's the managing entity who should be liable and who the state should pursue, not necessarily silent interests that just have money in it and not no part of actually running the organization. So that's the intent. That's the gravamen of the bill, and I support it.
Okay. Representative Almy.
Thank you. My only problem with the bill could be solved by amendment. It takes out members and it says any person in a managerial capacity of the limited liability company. Or we need a definition of managerial, I think. I have a acquaintance in Lebanon who, this information about 10 years old now, but has had 25 different LLCs, and about 10 of them now are on different LLCs owning each either a gas station and a gas station and a convenience store, or he's got one that is a coffee shop. He's got two now that are a coffee shop and a car wash. And he doesn't manage those day to day. He hires somebody who frequently he brings up from the guy who is stocking the shelves to be there and handle the money. That guy is not, I know one of them quite well, is not paid enough that he would have any money you could get away from him without putting him in the poor farm. So I think that in the case of limited liability companies, you really need to define managerial to be the person who I'm not sure what the legal language would be, but tells the people in his employ how to do things. Or to add on to this, any person, any member holding more than, say, 30% of the 30% share in the business.
Okay. I think Representative Spilsbury may have an answer for that.
I will come back to that, but just more broadly, I think this is a significant bill that we should pass. Unfortunately, it sort of fits into a very, very murky area of law, and I believe that Representative Ullery during our hearing very constructively suggested that maybe something that this committee should put on its docket for the future is a more comprehensive review of corporate liability, limitations of liability, and specifically liability for tax-related issues. But in the meantime, I think the bill makes an important step in the right direction. The fundamental purpose of corporate law is to limit liability. And the purpose to limit liability is to attract investment, right? So this particular law as it exists essentially carves out an exception from that. And it says, notwithstanding normal principles of limitations of liability, when a business collects meals and rooms tax, which are essentially owed by the visitor. They're in a fiduciary relationship. They are taking custody of funds properly due to the state. And so we're going to pierce behind the veil of corporate liability and make that person responsible for abusing the public trust. Okay. Given that this is a exception from those normal principles, it should be relatively narrow. And interestingly, in the sentence on lines 9 and 10, it is relatively narrow with respect to corporations. And it's not totally clear, but I take that to mean both C Corps and subchapter S. So it says, for the purpose of this section, operator in the case of corporations includes the president, the treasurer, or other person in a managerial capacity of said corporation. That is excellent language. It could be maybe flushed out a bit more. Corporations does, in fact, include C Corps and subchapter S. Now, what's a subchapter S? Without getting into it, it's really just simply it's a vehicle for allowing incorporation with certain tax advantages, namely pass-through tax liability. Well, that's essentially where LLCs come into the law. The whole point of LLCs was to have something simpler than a C corporation or a pre-existing subchapter S. And so why then do we, in contrast, have the current law saying in the next sentence that in the case of a limited liability company, operator includes members and any other person in a managerial capacity? I think it's, just imagine if being a shareholder of a C corporation subjected you to having a lien placed on your personal home because the guy in charge of the corporation didn't remit the funds. Okay. The LLC members, the passive investors, need the same kind of protection that a shareholder in a C Corp has. This bill gives it to them. Now, back to Representative Almey's question. You brought this up in the hearing as well, and I think it's a legitimate question, but I don't think actually that the bill is ambiguous on this point. You've made the distinction more or less, I think, between somebody who is operating, for sake of illustration, the gas station, but is not himself a member of the LLC or therefore an owner in the business. But you've got to read this wording so it says person in a managerial capacity of the limited liability company. So it's not just somebody who's been hired to manage the gas station, which is one of a chain of 20. This specifically is limited to and referring to somebody in a managerial capacity of the corporate organization, the LLC itself. So I think we illustrated in the hearing in questions and somewhat now that there are ambiguities in this field of law, but they're not the fault of this bill. And this bill actually is a step in the right direction, and we shouldn't hold it up just because the area of law could be clearer.
Representative Almey.
Yes, I'm talking about people, and I in my area, I think that it is normal that have multiple limited liability companies, but they are the principal owner of all of them. Each of them is legally separate. And as I understood LLCs, one of the reasons for starting them was to have a legal separateness between several businesses, so that if you caused a major oil spill in one of them, they couldn't collect from your next gas station because they were two separate LLCs.
That's absolutely correct, but I'm not sure it in any way defeats the purpose of this bill. The purpose of this bill is to say, who is it? What specific individual is it that we can hold personally reliable for the failure to remit meals and rentals tax that was collected from a visitor or, so you're correct, but in any given case, there is a specific business entity that has the obligation of collecting and remitting the meals and rooms tax, and that's what this
And you
limits it.
believe that would be the owner of the LLC rather than the person in the LLC who is working for the LLC.
Right. When this says managerial capacity of the LLC, that to me by definition requires that to be the managing member, not any old member, and definitely not an employee.
Okay. Thank you.
I'll just add that each year when you file an annual report with the state, you have to specify who that managerial member is. Was that your point? Well, let me go to Representative Fellows. I know she's been waiting for a while.
So what I just wanted to say is now that I've heard it explained like about 3 times, thank you for doing that, that I understand the concept of linking managerial to be a member. So it would be a member of the LLC that has the managerial responsibilities. So I understand that. I don't think this language makes that clear. Maybe if that's what you're thinking, that maybe it has to be more explicit and say a member or members that have managerial members who have managerial experience instead of saying person with managerial.
Yeah, I think you're asking a very legitimate question, and if I was drafting this with you, I think we would have chosen different language. But bear in mind that the problem that you're describing is largely in the current law and not introduced by this bill, right? So I wrote in my notes during the hearing, wouldn't it be better to define operator, manager, managerial capacity? Sure, it would be a clearer statute if we did that. But I think by definition, the person in a managerial capacity of the limited liability company can only be a member. So it is, bottom line, the same outcome.
Did you have a follow-up?
Yes, I just would ask if we want to pass this bill that we fix that. Just fix that wording.
I think your concern was if it's fixed, it needs to be fixed in a different
I'm
area.
suggesting it's not necessary to fix it. I'm also suggesting that the problem you're pointing to is in the existing statute, not in the bill.
Representative Ullery.
Yeah, and that goes to my point as well, because if you take a look at the LLC, many of us have LLCs. If you take a look at the LLC statute, some of the terms are defined in that. This section is going to go into the LLC section. So those definitions that are already in law exist. Now, could the LLC statute be more clear? Yes. But does this say, in the phraseology that was just quoted by Representative Spilsbury, does it say what we want it to say? And it says a manager of the LLC, not the manager of the business being run. It's not the shift manager, it's the manager of the LLC, which is a distinct person.
Representative Southworth.
Thank you. Just a reminder, the manager is listed on the form that you have to file, and that can't be the gas station daily person or any of that.
And it can be a member, a manager. The form allows for a member, manager, or a manager on the state form that's filed annually. Representative Ames.
I just think that we've got DRA in the room. Keen Wong is here, and I'd like to hear his he may have other observations, but I'd like to hear from him regarding this language and how it would work for the DRA or not work so well, or how they might fill out some ambiguities just through rulemaking.
Okay, yeah, makes
Mr.
sense.
Chairman?
Mr. Wong. Yeah.
I concur with Representative Ames, but I just want to throw one more thought in beforehand so that Keen can react to it. But I think that in line 11, where this deletes members and then deletes other, it actually makes the point clearer. The existing statute is saying includes members and other persons. Well, if you're not a member, what kind of an other right? But removing these three words makes it more clear that we're talking about only the member or members who are in a managerial capacity. So I think it actually improves on the current law in that respect as well.
Thank you. Please introduce yourselves.
Good afternoon. My name is Keen Ming Wong, Tax Policy Counsel with the New Hampshire Department of Revenue.
And I'm Peter Roth. I'm an attorney with the Department of Revenue Administration.
Thank you.
Good afternoon. Thank you for taking the time to hear us. We've been following the conversation, and I think what just wanted to clarify that for LLCs, the managers, the persons with the capacity to manage the LLC, not necessarily would be limited to just members. There could be managers that the members have hired to manage the LLC. So I believe that taking out the language here includes members, and so the language of members and other, and the word other. So this therefore operator in the case of a limited liability company includes persons in a managerial capacity would include members who are managing as well as non-members who are hired to manage the LLC. That's how we read the language of the proposed amendment. And then to sort of assist in this, we've tried to draft some kind of language to define what a person in a managerial capacity to be in an LLC. And I made some drafts and I'll hand it out.
Great.
Yeah, I think from our perspective, it's important to remember that many LLCs don't have somebody who's a named managing member. They just have members. And so we have to sort of peel the onion a little bit and find out who's actually running the business. And as Keen just said, it could be an employee who's in charge of paying the tax bill, who neglects to do that. But that employee may not have any equity stake in the business itself.
A question, Mr. Chairman,
Yes.
for the attorney. Thank you. Has there been a problem for the DRA in collecting meals and room taxes from LLCs here in the state?
We often have trouble collecting meals and rentals taxes from LLCs. They tend to be very cash based. They often their assets aren't worth actually the entity's assets itself are not worth very much, or they have liens on them from commercial lenders and employees. And then we find that they fractionate the business among members. And so we've had a couple of instances where you have the brilliant chef running the restaurant, and he brings in his brother-in-law and his brother-in-law's sister and various people to participate in the business, and they all put money in. They often sign an operating agreement, which is a contract among them, which gives the members certain rights to have information and to control how the business is operated. And they often will sit back and count on the brilliant chef to run it. And one thing that we've seen is that brilliant chefs do not make terribly brilliant business people. And so we had one case where the brilliant chef died and left things kind of in a state of disarray. And the members who had been letting the brilliant chef run it, and it was a relatively successful restaurant, they discovered hadn't paid the meals and rentals taxes in 4 or 5 years. And so it was kind of a mess to untangle who is going to be liable for those unpaid meals and rentals taxes.
I have a question. So regardless of who's been hired to manage the operation or pay the taxes, the M&R taxes, isn't it required on the state form renewing the corporate status to identify a member or a manager? If it's a member manager, and wouldn't that person therefore be the responsible party?
The forms as I've seen them don't exact a great deal of rigor, and they change members and managers with some regularity without necessarily updating the forms that they submit on an annual basis to the Secretary of State's office.
On that form, isn't there if I'm remembering correctly, there's a spot where you have to identify who's the manager, whether it's a manager in name or a member manager?
Yeah, they don't list everybody. They only have to list one person, and I don't know that they need to identify that person as a manager.
Okay. Representative Ames.
I'm sorry. I've looked at a lot of them, and I'm just kind of got it sort of swirling in my head what they look like. And I wish I had the form in front of me, but I don't. I'm sorry.
I've looked at this that you just handed out. Thank you for doing it. I think that this is what we need to have. That's my view. The managerial capacity is filled with those two words alone are filled with ambiguity. This fleshes out the meaning of the concept without trying to boil it down to a single word. And there are various characteristics that you look at, and the department makes a judgment based on those various facts and circumstances. It's the right way to go. So I would encourage moving to get an amendment to this bill before we go forward that would go down this alley. And there are others here who are more familiar with LLCs and this kind of business than I am. So I welcome being told that's not the best way to go.
Representative Spilsbury.
Within the time and the constraint of the committee, I think Representative Ames' suggestion is constructive. I think that coming to us with this draft is helpful. This goes back to what I said when I was listening in the hearing. I made a note to myself, it would be best if we defined operator, manager, and managerial capacity. So they are inherently fuzzy. And I think that the notion of determining who is an operator for the purposes of this statute through a consideration of a range of facts is a good approach, as opposed to, one specific litmus test. It's kind of like how you determine domicile or something like that. But it's a lot. More words here than there are in the statute we're amending, and we're only amending it by taking out 3 words. So is it your intention that this is a way of determining the operator of an LLC only for the purpose of this one statute? Or is this an approach you're thinking is a way to determine who is responsible for an LLC's activity throughout corporate law as regulated by the state of New Hampshire in many statutes?
Thank you for that question. I think our intention is that this would apply to this unique circumstances, as you pointed out, where this is the exception to the norm of limited liability and protection from liability of a corporate statute. We derived these factors from case law that involves the Internal Revenue Service and how it determines whether a person has personal liability for payroll taxes, for example. And so the case law has come up with this 7-factor formula, or it's not really a formula, but it's 7 factors.
Thank you.
Representative Ames, did you have a follow-up, Representative Ames?
My colleague was bending my ear, so.
Do you have a follow-up?
I'll follow up to Representative Spilsbury. Okay. All right. Representative Platt.
Is it your contention then that the bill would be fortified by putting this language in it? Or is that something you can do by rulemaking?
No.
I'll let Keen answer that one.
I think it would be good to have some kind of guidance within the statute, and then if we do have if there's more ambiguity, we can sort of try to clear that up in the rules, and then because there are instances where potentially we could say, okay, where the OLS or JAILCOM might say, okay, where is your guidance in terms of where's your limitation in terms of defining manager capacity? So with statutory language and statutory guidance, then we can, if there is a need to, we can expand further or define further certain aspects of the
Follow up, Mr. Chair?
Follow up.
In the case of the brilliant chef, what did you cook up?
Oh, he does that.
Good one.
Representative, we'll go this way. Representative Almy.
Yes, but I was under the impression that a number of smaller LLCs, even if they're owned by the same person, doesn't have officers or a board. So this would be a pick and choose what applies in this case, or it would be in everything.
That is correct, Representative. Not all LLCs would have a board of directors, and not all LLCs would hire a specific manager to manage the LLCs. It could be managed by the manager themselves. So that's why it's a bit challenging to have a specific, as Representative Spilsbury said, a specific litmus test to define, okay, who is this manager capacity, and that's why the reason for this listing.
And these factors aren't intended to be, you need to check all the boxes. It could be that one factor could be dispositive and all the other factors don't apply. Or it could be, three of them work and not the other four.
All right. Next is Representative Ullery.
Yes, that follows through. The only comment it's one comment in a couple of different places. You're using the term managerial capacity, and yet in the LLC law, a manager is a specific individual, but you're not talking about that kind of member manager. You're talking about a supervisor or a supervisory capacity. And if you go down through your laundry list, that's all supervisory activity, not necessarily LLC participation capacity that a member would be a member of, that is an investment member. Which we're trying to do is protect the investment members from from the supervisory members, the members engaged in I'm trying to distinguish between capital M member LLC and small m manager doing the job. So it's a supervisory individual. And your language, including but not limited to, seems to cover everything in there. Does supervisory meet your definition of the individual who would be responsible for defrauding the state?
Thank you for that question. I think the answer is these factors would include people who don't have an equity stake in the business. So it could include the person who's hired as a manager and is responsible for making the sequestration and remittance of the taxes that were collected for the state, but failed to do so. So it's broader than simply getting into the mechanics of an LLC, but and this is and gets into the sort of the overall operation of the business. And this is how we've always interpreted it. Although, I think I would say that, we're not, despite being the Department of Revenue, we're not unreasonable people. And, if you said, yeah, there's a 19-year-old manager who hires and fires people and works at night, we're going to make him liable? No, I don't think so. We would look at sort of the whole picture and decide, does this person have enough responsibility that it's sort of fair and reasonable to make them liable for the unpaid meals and rentals taxes?
Follow up.
So let me just follow up. If that person, in trying to make that determination, if the person you think is ultimately responsible is a member, and let's say this passes and that person's a member, you could deem them a member manager and therefore hold them accountable.
I think that's correct. If a person was a member, but also had responsibilities in operating the business, or had the opportunity to have those responsibilities, but basically puts their head in the sand, we could then treat that person as an operator for purposes of this liability.
Okay, thank you. What happened to your question, Representative Ulrich?
I am not sure, but it seems as though we're pretty much deep into the woods, that there needs to be more work on this, and I think you can.
Well,
bring
it
this-
seems to me we might have just come full circle, and by passing this is not a problem, because they can still determine who is the managerial, who has managerial responsibility and therefore is accountable.
And while I realize we cannot bind a future legislature, we really, the legislature, capital L, needs to take a look at these rules. There's no reference in this particular bill to the meaning of the terms, member and member manager and all that type of stuff that exists within the LLC law, and making a connection to this law. And the follow-up question on that was, what do you do when it was done deliberately? Is that a criminal action, or just is there only civil penalties available?
No, it's definitely a crime. Our rules provide that the funds that are collected from the customers are held in trust for the state. And if they are taken from that trust, that's an act of conversion, which is essentially a theft. And then in our criminal code, the RSA 21J 39, if I'm not mistaken, I think there's a provision in there for somebody who does steal money from the state. And we've had, I think we gave you an example of one, but we've had a number of successful criminal prosecutions of people who take the money from the customers and find ways to intentionally use it to their own benefit.
Representative Fellows.
Thank you. Can you tell me I'm wondering if this is being treated differently than some similar situations. So what if this business hadn't paid its BET tax? How would you determine who to go after? And I realize you're the attorney for DRA, but what if they don't pay the electric bill or some other, supplier?
So we're dealing with a tax here that has been called a trust fund tax. So this is a tax on the customer and the operator, whether it's a hotel or a restaurant. Their duty is a fiduciary duty to collect that tax and give it to us, because they're just really kind of a pass-through. BET and the other income taxes are a tax on the operator or the owner's income. So you could have an LLC running a successful restaurant owe both M&R, the meals and rentals tax, and owe business taxes. For us to get personal liability against a restaurant or business owner, any business owner, for the income taxes is a more difficult and complicated exercise. We have to either pierce the corporate veil, which is complicated, or prove that there was a sham transaction, or that the owner was a transferee of the business assets at a time when the business was essentially insolvent. So there are there's a specific statute for a couple of those things, and the alter ego, piercing the veil is a sort of a common law theory with some basis in statute, but that's how we go after. And I mean, it's a very unusual set of circumstances. An individual who has failed to pay income taxes in a way that, we find personal liability. But
I asked BT specifically because
Well,
I didn't want to get into that.
Let me answer that in the sense that I think what the point here is the money collected, the tax collected on M&R, the customer paid that. That's not the business doesn't have any needs to pass that on to the state. When it's business income, the business they're paying taxes on their own business income. So it's a totally different scenario. I think that's what you're.
So that's
trying
why
to-
that's why I didn't ask about income. I asked about the BE tax, which is on a percentage of the employee's wages, right? And also like a supplier.
Well, the BET is an enterprise value tax, and one of the ways that we measure that is on payroll, but it's not actually a payroll tax. It's just the payroll is a convenient metric for determining what the enterprise value is. I think I got that right. Thank you. I'm a little out of my league here, but I'm pretty sure that we treat it more like the income tax, as a tax on the business itself rather than on the business's customers.
Representative Orrs.
Thank you, Mr. Chair, and thanks for taking my question. So all this conversation sounds to me like it's on the back end. I think the real solution is to put the emphasis on the front end, and companies like a restaurant, let's say Olive Garden or somebody, if they're collecting meals and rooms tax, they should be forced monthly or quarterly to submit a documentation and a check. Right now, that doesn't sound like it's happening. So we wait till after the fact. And if we got Super Chef that waits 4 years, and he's doing his thing or she's doing her thing, and they're pocketing the money, that's what it sounds like. There's no mechanism to trip that, where if you put the emphasis on, we're going to force them to submit a quarterly, it sounds to me like that's the answer. We just, let's get right to the meat of it here.
We do actually require every business to obtain a license from us, and that tells us that there's an operator, and it often identifies who the operator people are, and then we require them to file a monthly return, which tells us how much they took in tax and how much they're turning over to us, and then we have a web-based portal that they can file the return and make the payment through. We have a collections department that monitors the best they can the businesses that we know about, and then sometimes businesses fly under the radar, like the Brilliant Chef I mentioned. And so
Thank you.
we do the best we can.
Yeah, just a quick follow-up. I just wanted to, so you do have somebody monitoring these businesses? Because it sounded to me like initially you were saying, and I'm thinking, gee, we just need somebody then to look at it. But I guess I'm not sure why. How does it fall through
I'm
the
going to
cracks?
interrupt you, Representative Orrs. I don't think that's the issue at hand.
Okay.
The issue here is members versus managers and collectability of that should they not be paying. So I'm going to go to Representative Spilsbury, who's had his light on for a little while.
Thank you, Mr. Chairman. I believe I have, in fact, come full circle. And I'm going to suggest, as you suggested a couple minutes ago, this is a classic instance where we should rely on the agency to do the rulemaking. The phrase operator in a managerial capacity of the limited liability corporation is sufficient for statutory purposes. In fact, amending the bill to include something that is a 7-factor sliding scale of which some could be and some aren't, that's inherently too fuzzy for legislation. And I'm backing away from it myself I would like us to pass the bill as it was sent to us by the Senate. I'd like to just clarify two things that have come up. The analogy that I used, Representative Fellows, in the hearing was to the federal income tax employee withholdings. That's a situation which is really more parallel to this, where the taxpayer has their funds sequestered and held by in trust, right? So in this case, the taxpayer is the person who buys the meal or buys the room. We should also, therefore, in that context, remember that this is just one hook on enforcing that obligation. There is criminal liability. In the portion of my career in which I was focused on business restructure and workout and refinance, it was very common to come in and find that the company that was struggling to survive was also in arrears on their federal employee tax withholding. And so the very first thing we put the focus on in those engagements was to resolve the federal tax problem because the consequences are severe, right? There is a difference between something which is overtly fraud, essentially theft from the business, theft of those trust funds for your own personal purposes. It can get much more ambiguous than that because often it's just simply a business that is struggling to stay alive, and they've got a check balance, they've got a balance in their checking account, and they've got a checkbook, and they just start writing checks in the order in which they think is necessary to survive, and that check to the DRA didn't come up in the top priority. There's less animus and less criminal intent in that respect. So this is such a confusing area. This bill relates exclusively to one remedy. Can we pierce the corporate veil and put a lien on your home? I think we need to pass the bill and let the DRA sort out how to interpret those particular terms.
Thank you. Okay, I think we're almost ready to move on to a couple more questions or statements. Representative Almy.
Yes, on this is just something that is not on here, but that you mentioned, which is that you would go after a member who had chosen not to pay attention to the running of the business if you couldn't get anything out of the manager, I guess. Wouldn't that end up with the same situation that they are trying to avoid, that the rest of the members of the LLC would be liable? Because didn't they all choose not to get involved?
If I understand the question, I think the answer is under the, as I mentioned, many of these organizations have an operating agreement, and it's a contract between the members that establishes what their rights are with respect to the operation of the business. And those operating agreements are not lodged at the Secretary of State's office, and they're private agreements, and sometimes the members have them, sometimes they don't. But those operating agreements describe in them what rights a given member has with respect to running the business. And they often give them rights to have information provided to them so that they can see that the accounts are being paid properly. And they have rights to request an accounting, and they have rights to change the management of the business. And so I think the point that I was making is if a member has those rights, but puts their head in the sand and decides not to worry about the business because they're collecting their share of the profits from the business, everything seems to be going well. But in fact, the actual manager is neglecting paying the DRA. Then we think it's fair to say, you owed a bit more diligence to this problem, and that you can't claim ignorance when that you were essentially engaged in willful blindness.
It sounds to me like it's effectively the difference between a silent partner who invested but isn't really involved, but you at the DRA have determined, okay, this person isn't really a silent partner member. This is actually someone who's been involved with decision making or managerial capacity, then they are liable.
Yes.
Thank you. Representative Fellows?
Yes. Why don't we consider having the entity that needs to pay room and meals tax give DRA a form that says who the specific name of the person that is going to be responsible for the payment of this tax. And then there would be some kind of, and tell them that they have to update it whenever that changes, and maybe make a penalty if they don't keep, maybe no penalty, but I don't want them to get away with like putting a name on there and the person's like long gone and it still sits there. Maybe make it update it frequently.
We actually do that. The license application form requires them to list who their officers and who's managing that kind of information. When we're looking down the list at members that perhaps we didn't know about, it's usually because the people at the top of the list are gone or are bankrupt or otherwise insolvent and don't have the money to pay. So we kind of start with what's on our application form. Who's really running this business? And then we find, oh yeah, that's the brilliant chef. He's dead. So now let's go see who else there is. And that's the kind of the analysis we do, because we don't like to work harder than we have to. We want to work smarter, not harder. And so we start with the more obvious and logical targets, and when we're unsuccessful there, then we move down the list.
Thank you. I'm going to end the work session on SB 585. Okay, I'm going to open the work session on SB 546. Removing the requirement that an executory interest be conveyed. Is that right? Oh, removing the executory interest. Okay, comments? We covered it thoroughly, and your thoughts? Okay. Representative Spilsbury.
Thank you, Mr. Chair. I happen to be another one of LCHIP's fans. There are two projects in recent years in my hometown, Charlestown, that have been done with LCHIP funds, restoration of our town hall and of our library, both historic 19th century structures, and I'm convinced it would not have occurred without their assistance. Having said that, that's a plug. I think that this is an absolutely simple, straightforward bill. It's clear that they don't need the executory interest to pass to the state. The state and the AG have opined that there's an adequate set of protections in the trust relationship, and I don't think the bill really raises any kinds of questions. I'm all for it.
Okay, thank you. Let me just kind of ask the committee a question. I had raised a question on line 5 where the word acquire was crossed out and changed to provide funding for the acquisition. So how do people feel like about that? Representative Almy.
I just wanted to make a comment.
Yeah.
I was in on the beginning of LCHIP.
Okay.
And on some of the private discussions before the bill went in. And it makes perfect sense that at first they were thinking about the program requiring the properties themselves. But they soon in trying to use this model realized it was going to take a great deal of administrative capacity in LCHIP that was going to be increasingly making it impossible for them to do much except administer past grants. And there was an LSIP before that, 20, 30 years before that, on which I think may have run into that problem because it was originally federally funded. And so they changed that, but as she said, they forgot to change this sentence so that what is happening now, which my town also has profited from twice, I think, except that you have to be sure that LCHIP is going to be able to give you the money, and they frequently can't. And so you've made an agreement with somebody and you have to pay the whole thing. And we've run into that a few times. But I think that part of it makes perfect sense.
Okay.
The whole thing makes perfect sense.
All right. Thank you. Representative Fellows.
Yeah, so I originally had some concerns about, decades down the line, the use of property that was part of this program turned into something it wasn't supposed to be. But I'm guessing now that if you look at lines 16 through 18, that, maybe one of the lawyers could explain it to me, but I'm hoping that part would allow the state to have information and keep information about what the property is supposed to be used for, and will somehow, I'm not sure how they find out when it's been sold, but somehow know if there are if things are about to happen that shouldn't happen.
So
Representative Spilsbury.
it just happens that I'm preparing to acquire a piece of land that is in fact subject to a conservation easement, and it's all recorded. It's a legal document. It's just as enforceable as if the power company had obtained an easement to put power lines down the edge of your property. So I think, no, you can rest easy.
Representative Ames.
Yeah, I think that bill is a good bill. It's a simple cleanup, clarification, and we should just go ahead with it.
All right.
It's essentially what everybody's been saying.
Thank you. I'm going to close the work session on 546. Okay. Now, obviously the next step here we have is the executive session, but we probably should break momentarily, although I'm sensing kind of agreement on all 5 of these, but I might be wrong. I don't, let me just take a break for a minute here and discuss a couple things. For those of you wondering, we are going to start an exec session in the next couple minutes. Yes. There will be no caucus.
You have that other sheet you want to.
Oh, yeah. Yeah, you'll have to just figure out who's who here. Let's see, we really need an updated, well, I don't know.
Okay, so who's Representative Horrigan sitting in for?
Yeah. What's that? Only when he calls the roll.
Just got confused.
So I've got the Republican.
That's good. I think you're well seated.
Catherine is representing Laurie Sanborn. What's that? It seems like he left. I don't know what happened to him. Something must have happened. He had to leave.
Yeah, we can go ahead because.
No, I'm fine. Yeah, we're in agreement. Yeah.
Excuse me, Mr. Chairman. It's me. For the record, I am a member of the Board of Directors of LCHIP, but since I'm here as a substitute, my vote belongs to
Representative Doucette, you can
Yes.
follow his lead.
Follow his
So
lead,
that's
yes.
not a problem,
Thank you.
as we'd expect from all the subs to follow the lead of the vice chair here. Yeah, or the ranking member.
Representative Almy.
Representative Almey's the ranking member of the. Okay.
Mr. Chair.
Where are we? Yeah.
And for the record, once again, I wanted to state the fact that I am an executive director of a charity that receives charitable gambling monies.
Okay.
I personally do not receive any monies, but my nonprofit does.
Okay. Thank you.
Mr. Chair, I should also state that I am on the Board of Directors and former Treasurer, Lions Sight and Hearing Foundation of New Hampshire, Inc., which has received charitable gaming money. Received nothing personally.
Okay, let's get started. I'm going to open the executive session on SB 472 and recognize Representative Doucette for a motion.
Thank you, Mr. Chairman. I move ought to pass on SB 472 FN.
Do I have a second? Second by Representative Almy. Would you like to speak to your motion?
For all reasons discussed during testimony and work session, I hope we'll all support the ought to pass motion.
Thank you. Any further comment? Seeing none, the clerk will call the roll.
Representative Doucette,
Yes.
Representative Representative Ullery,
Yes.
Representative Kenny, Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Renzullo,
Yes.
Representative Orr stepped out. Representative Rochefort,
Yes.
Representative Willett,
Yes.
Representative Almy,
Yes.
Representative Ames, Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Cahill,
Yes.
Representative Smith,
Uh,
Horrigan.
I'm Representative Horrigan, filling in Representative Smith, so I also vote yes.
Yes, I had it written down, I just screwed up.
I've
Which
done
is-
that before.
Which is not the first time. And the chair,
Yes.
the vote is 19-0, one not voting.
Okay, the vote being 19-0, we'll, without objection, we'll put this on consent. And I'll close the exec session on SB 472. We'll now open the exec session on SB 432 and recognize Representative Doucette.
Thank you, Mr. Chairman. I move ITL on SB 432 FN.
Do I have a second?
Yes.
Representative Platt seconds it. Would you like to speak to your motion?
Again, hearing the testimony we heard, I believe there's much room to be discussed and it'd be wrong to pass this legislation at this time.
Mr. Chairman,
Yes, Representative
I
Shannon.
will be voting against this ITL. The para pool that Representative Doucette sent to us, the definitions, do not explicitly state that ADW is covered for betting out of state. It's mostly, the para pool is for conduct within the state, for horse racing, for greyhounds, for you put your money in then. That's why I feel that these are for licenses held in the state at the location. And I feel that I will have to vote no on this, and I will not allow to go to consent when the time comes.
Okay, Representative Doucette.
Yeah, and I will be supporting the ITL in that the argument was made under the Interstate Horse Racing Act, which states clearly in that piece of federal legislation that it has to comply with the laws of the state where the bet is being made and the state in which the bet originates. We have laws that dictate that, and I believe those laws are not being addressed. As far as the rule that spells out exactly what our laws are in New Hampshire, they're not complying with those rules right now and those laws, in my estimation.
Representative Fellows.
Yes, I would just like to say that I support the ITL because the part about the, what is it called? Charitable third-party financial intermediary program is not feasible. It makes it look like there would be some money available to go to municipalities, but it's pretty clear that $20,000 a year will not be enough for this to operate, and that the fact that current charities receiving money for charitable gambling will take priority over the towns getting any money, and the municipalities are not going to get anything of any significance.
Representative Almy.
Thank you. I also am not going to support the ITL, but primarily because I think that there are a lot of different pieces of law that we have not really been able to see yet. Representative Doucette told me that the one that he sent us is not the one he should have sent us, and has to be somewhere else in the statute. And the question of what happens when the notwithstanding clause is put in, for me is an opposite problem than one is for some of my colleagues. I don't think that we're at the stage yet where we should be voting on it, but I don't want anyone else on the Democratic side to follow my lead. Whichever, you make up your own minds. Thank you.
Representative Ames.
Yeah, I will be on the ITL side of this. And I think it's basically a judgment that this has a number of incomplete pieces that I'm not ready to support at this time, and I don't think they're necessary to go forward on at this time.
Thank you. All right, seeing no more questions here or statements, I'll ask the clerk to call the roll.
This is an ITL motion for Senate Bill 432 FN. Representative Doucette.
Yes.
Representative Ullery.
Yes.
Representative Kenny.
Yes.
Representative Spilsbury.
Yes.
Representative Platt votes yes. Representative Renzullo.
Yes.
Representative Orr stepped out. Representative Rochefort.
Yes.
Representative Willett.
Yes.
Representative Almy.
No.
Representative Ames.
Yes.
Representative Southworth.
Yes.
Representative Malloy.
No.
Representative Schomburg.
No.
Representative Fellows.
Yes.
Representative Bolton.
No.
Representative Elberger.
Yes.
Representative Cahill.
No.
Representative Horrigan.
No.
The chair.
Yes.
Yep, 13 to 6, 1 not voting. This is the final count.
Okay, well, Representative Schamberg got his wish. It won't be on consent.
Thank you, Mr. Chairman.
And who was the minority author?
Minority.
We share. I'll write and then I'll send it over to you. Okay.
Representative Schamberg. Okay, we'll close the exec section on SB 432. I'll now open the exec session on SB 597. Do I have someone who'd like to make a motion? Yes, Representative Elberger.
I move ought to pass.
Do I have a second? Second by Representative Doucette. Would you like to speak to your motion, Representative Elberger?
No, I think we all pretty much spoke out.
Okay. Seeing no more comments, the clerk will call the roll when he's ready on SB 597.
The roll is ought to pass in 597. Representative Doucette.
Yes.
Representative Ullery.
Yes.
Representative Kenny.
Yes.
Representative Spilsbury.
Yes.
Representative Platt votes yes. Representative Renzullo.
Yes.
Representative Orr stepped out. Representative Rochefort.
Yes.
Representative Willett.
Yes.
Representative Almy.
Yes.
Representative Ames.
Yes.
Representative Southworth.
Yes.
Representative Malloy.
Yes.
Representative Schomburg.
Yes.
Representative Fellows.
No.
Representative Bolton.
Yes.
Representative Elberger.
Yes.
Representative Cahill.
Yes.
Representative Horrigan.
Yes.
And the chair.
Yes.
Okay, the final vote is 18 to 1, 1 not voting.
Do you have an objection to consent, Representative Fellows? Okay, then we will put this on consent. And I'll close the exec session on SB 597. SB 585, we're going to hold that off till our next meeting. And I would ask that Representative Ames and Representative Spilsbury work on any potential language they think might clarify, if any. And anyone else who is passionate certainly can join in on that, but Representative Elberger will do the report on 597, correct? Okay.
Yesterday.
Today being Tuesday, as soon as possible. The speakers asked that we do these as soon as possible. If you can get it to me by tomorrow morning, if that's possible. I mean, by tomorrow morning by 12 noon. Yeah, anyone doing reports, if you can get them to me by 12 noon tomorrow. The speakers asked that we try to get these done as quickly after exec as possible. Put your microphone on, please.
Are we going to do 546?
Yes,
Oh.
that's next. Okay, I just wanted to say that 585, we're not going to exec today. And what I'm planning, I don't know the exact date yet, but the next time we meet, which will not be next week, I'm also going to check with DRA to see if when we do this, because this is it for our bills, and I don't want to come in just for that one. If we can also get an update from DRA as to the revenue projections, so we will exec SB 585 and do revenue projections, whatever that day is. It could be 2 weeks from today. I just have to make sure that DRA would be ready for revenue projections.
Yeah, we discussed that. I think they may be ready by the 14th, but you need to ask them.
Yeah, if they're not ready in 2 weeks, our cutoff here is we have to exec everything by May 16th. And I'm trying to avoid having everyone come in just to exec one bill. But if I can't piggyback DRA at the same time, we may have to come in and exec that one bill.
Mr. Chair, what are the odds of us getting second committee bills?
I don't know. Low. I would say low. Yeah, I mean, there's always a chance we'd get a second committee bill and have to, but I'm not aware of any at the present time.
I do have a dam bill, which
Is it coming to Ways and Means?
it may, it is a second committee bill. It doesn't say, I've been up until which committee it's
Yeah.
going to, but I know the last one went to you.
I'm trying to think. I did go to a meeting where there were only 3 or 4 committees that had second committee bills coming, and Ways and Means wasn't one of them.
Oh,
But things could always change. But
Well, that-
currently there's no plan for a second committee bill.
okay.
We're-
But they haven't done that this year.
Representative Paulette?
I'm hoping that your committee will strip out the financing part of it so it doesn't come to Ways and Means.
Well,
That's yes, we are definitely considering that.
okay. So that's the status on 585. We'll hold off, and next time we meet, we'll exec that one. Okay. So, Representative Almy.
Aren't we doing 546?
Yeah, I'm going to do that now. But I just wanted to, I'm just kind of going in order. I want people to know what's happening with 585. Okay, so now I'll open the exec session on SB 546. Would someone like to make a motion on that? Representative Spilsbury.
Thank you, Mr. Chair. I move OTP on SB 546.
Second.
Second by Representative Almy. And would you like to speak to your motion, Representative Spilsbury?
Yes, I think the bill proved non-controversial, and it's mostly in the nature of a housekeeping bill to reconcile the language in the statute to the convention of providing funding for acquisition rather than directly acquiring, and also for the fact that the state and the AG have determined that the executory interest is not a important element in protecting the interest of the state, and that the trust relationship does that adequately. So easy bill for us to pass.
Any further comments? Seeing none, the clerk will call the roll.
This is OTP on SB 546. Representative Doucette,
Yes.
Representative Ullery,
Yes.
Representative Kenny,
Yes.
Representative Spilsbury,
Yes?
Representative Platt votes yes. Representative Ronzullo,
Yes.
Representative Ors is not here. Representative Rochefort,
Yes.
Representative Almy. Excuse me, hold on. Representative Willett,
Yes.
Representative Almy,
Yes.
Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Kale,
Yes.
Representative Horrigan,
Yes.
and the chair.
Yes.
The vote is 19-0, one not voting.
Okay, any objection to consent? Seeing none, it'll go on consent. Okay, and I'll close the exec session on 5:46. All right, very good. We made it through that nicely. So again, we just have one bill left. Assuming we don't get any second committee bills, we are down to one bill to exec, SB 585. And as I said, we will not meet next week. So, and I'll try to find out as soon as possible what DRA's situation is, so that we will either meet 2 weeks from today or possibly 3 weeks from today, but we'll be very close to our deadline of May 16th of getting this out. The only caveat there would be if suddenly we do get a second committee bill, but we're not meeting next week. So,
Breaks my heart.
any questions, concerns? Yes, Representative Elberger. Possibly. As I said, I don't want to come back just to exec one bill. I want to get DRA updates as well. So if DRA says we're not ready, then it'll be after that. But I hope to find out in the next couple days. What's that? No. At a minimum, we're not meeting until 2 weeks from today, which is, if it's May 7th, that's the date. Okay. All right. Thank you, everybody. Good sigh response.
Nope.